Okay, so I went to see what time it is, which I have 20 minutes to 11.
Yes.
So that means I have an hour and 40 minutes to speak, 20 to 12. So 12:20 is when I should be finished. So if somebody will let me know when we get to maybe 12:10 so that I can wrap it up. We went, Pat let me go first today because I tend to be overly verbose and talk way too much, and she is shorter. She talks less. She's also shorter. But so I tend to go over a lot, and also I want everybody to be able to ask questions, but I'm going to try to wrap it up by 12:20. I have to say, if you have to have this training, you have to have 4 hours of training a year, and of course, they're not real hours, they're lawyer hours, which means it's a 50-minute hour, which is why I don't have to talk for 2 hours, but only an hour and 40 minutes. So there you go. My name is Verlindia Doss. I am the soon-to-be unemployed executive director of the Florida Commission on Ethics, 1 week and 6 days, not that anybody's counting. And as I speak again about this 4 hours of training, I understand this is being videotaped so that people can use it, people who couldn't get here or people who just enjoyed it so much they want to rerun. But if you're watching this and you're doing it for your 4-hour training, just remember that if we do fall short of 220 minutes, you'll need to pick up your extra minutes someplace else so that you can have your complete 4 hours. So first thing I want to do is get a little idea of who you are. First of all, how many have seen my act before when I was here last time? Okay. Well, you'll probably hear some of the same jokes over again. Sorry. It didn't really seem like I should really come up with all new material, a week and a half. But I'll do my best. We got a lot of Form 1 filers here. Any Form 6 filers? Okay, we'll be talking a little bit about financial disclosure and especially timely since it's due July 1st, and that's creeping up on us pretty quickly. So we'll go to a little bit about the background, who we are, what we do. The commission was started in 1974. That's actually 2 years before the Sunshine Amendment was added to the Florida Constitution by petition initiative under Governor Askew. The goal for us is to maintain the respect that people have in their government, ensure duties are performed improperly, and prevent the use of office for private gain. At the same time, we try, and we are statutorily tasked with trying, not to put undue obstacles in the way for people who want to become public officers and employees. We're a 9-member board. 5 are appointed by the governor, and right now we're a 7-member board because 2 of our members were appointed by Governor Scott before he left office. And when Governor DeSantis came in, those members had not been confirmed by the Senate yet, and he withdrew those 2 appointments and has not replaced those 2 members. So we're a 7-member board at the moment, but we're supposed to have 9. 5 from the governor, 2 from the Senate president, 2 from the House Speaker. A really neat thing about our board is that the House Speaker and the Senate president can only appoint 1 person of their own party. They have to appoint 1 person of the opposite party. And the governor can only appoint 3 people of his or her own party. They have to appoint 2 people from a different party. So you can't ever get this, completely out of whack, lopsided party situation on the board. There's always been a real concern about the Ethics Commission engaging in witch hunts, and this was one of the ways that they chose to try and prevent that from happening. So I'm going to tell you a little bit about what we do and the favorite way we have of interacting with people, which is through opinions. They come in a variety of flavors, formal, informal, and over the phone. I will say you have a great county attorney here, and Bob Schillinger, he is really, I think, the first line of defense when it comes to questions. And I don't always encourage people to go to their local government attorney because, like everything else, some are better and some are not as good. But I do encourage you. Bob calls us all the time. He sent us a lot of formal opinion requests. He's really diligent about trying to make sure everybody doesn't make a mistake about doing the right thing. So, but you're also free and more than welcome to call us directly. We have operators standing by to serve you, literally. A human being answers our phones, okay? And we have attorneys on call every day to take the more complicated questions. So we're happy to talk to you. As the incoming executive director, Chris Anderson, likes to say, we're open for business. So when people call, if it's a pretty straightforward question, we can answer it over the phone. That means that, you know, it's the facts are pretty clear. It's something the commission has dealt with before. It's just pretty upfront. If it's a little more complicated, sometimes we'll ask you to put the facts in either a letter or now more frequently an email, so that when we're looking at it, we're sure that you and I are talking about the same set of facts. Often we can answer people's questions informally. The commission does not rule on that, and it's not binding, but if it's a situation that's come up before where we're confident in the commission's precedent on the issue, we'll give you what we call an informal opinion. It's just a letter of guidance from our staff. And then if it's more novel, more complicated, hasn't been dealt with before, or is extremely high profile, then we will route it as a formal opinion. There are several advantages of an informal opinion, primarily the length of time. We try to have a 2-week turnaround period, but it's usually much quicker than that when we're able to do an informal opinion. Formal opinions take longer because the Ethics Commission has to rule on them, and they only meet every 6 weeks. They meet 8 times a year. So they do take longer, and they are binding, and they can be appealed to the district courts of appeal, although they rarely are. But if you need a formal opinion, and sometimes people do, they are invaluable. And I always say it kind of depends on how much CYA you need. You know, if you really need a lot, then sometimes the formal opinion is the way to go. If you're very confident that this is going to come back, people are going to be upset if you take this action or whatever, then usually a formal opinion is very helpful. Now, when you ask for an opinion, I have to say, the best candidates for opinions are the people who really just want to know the answer rather than people who are looking for a particular answer. We do have occasions sometimes when the requester is not happy with the answer, but of course the Ethics Commission and the Commission staff, they don't have a dog in the fight of what kind of answer you get. We just look at the law and what it says. So we love for you to deal with us through the opinion process. That's the way we like to deal with you. And also, we do not have the responsibility to rat you out. So if you call us and you say, "Oh my gosh, you won't believe what I just did," we aren't responsible to tell on you. So you can feel free to speak to us candidly about whatever your situation is. The way we'd rather not deal with you is through the complaint process, and that's when somebody, could be anybody, typically it's somebody who doesn't like you. Everybody always says this complaint is politically motivated, and I always say, well, what do you expect, your mother to file a complaint against you? No, it's always somebody who doesn't like you, of course. So the commission cannot, except in 2 instances, one of which doesn't matter here, and the other of which I will talk about later. Except in 2 instances, the commission cannot initiate a complaint on its own. Somebody has to file a complaint under oath on the form we promulgate, and it has to be against an individual public officer or employee. It can't just be against Monroe County, although we do get complaints against agencies, and I send them back and I say we can't investigate an agency. And it has to allege something within our ballpark. So, for example, we often get complaints that a government entity did not obey the Sunshine Law, or a person on the entity did not obey the Sunshine Law. That by itself does not implicate any ethics law. And if it doesn't, then I will send that complaint back and explain to the person what the shortcoming is, so that if they know something else or they can correct the deficiency, they can refile it. We can't accept complaints within 30 days of an election unless they're based on personal knowledge or information other than hearsay, which often they are based on personal knowledge or information other than hearsay, because often election complaints are filed based on the person's financial disclosure that they filed as a candidate. So we have received a number of those in the last year or so. If a complaint is filed against you, we will send a copy to you within 5 working days. Usually we will send it the same day or the next day. If you want to file a complaint against someone, understand that it is not confidential. Your name will be revealed to that person, and ultimately they may try and come after you for costs and fees, which I'll get to in just a second. The complaint process is this. Our staff lawyers review it to see if it's legally sufficient, meaning if everything that's in that piece of paper is true, might it implicate one of our laws? And if it's legally sufficient, it will be investigated by our staff investigators. If it's not sufficient, it will be given to the commission to vote on, because as staff, we don't just dismiss complaints. It's given to the commission to vote on to dismiss it. And they usually do, although not always. Sometimes they order it to be investigated. Once it's investigated, we send it to the Attorney General's office. The commission is an administrative agency, and like many administrative agencies, it has quasi-judicial responsibilities and also quasi-prosecutorial responsibilities. Unfortunately, it would violate the due process clause of the Constitution to have the judge and the prosecutor be the exact same person. So we have to find a way to split those duties up. So we contract with the Attorney General's office to provide the prosecutorial services. The advocate is what we call them in the Attorney General's office, which is a job I used to do many, many years ago, and a job Pat used to do, is to serve as the prosecutor in front of the commission. It represents the commission in its prosecutorial role. So once that case goes to that prosecutor, the commission and its staff mostly stay out of it. I mean, we might do things like, what's taking so long? When is this going to go to hearing? What's the status? But we do not control the prosecution, what witnesses are called, who gets subpoenaed, what day things are going to. We're out of it because we are serving in that quasi-judicial role. After it's prosecuted, which is before the Division of Administrative Hearings, it's an evidentiary hearing. It's a little less formal than a court situation, but still it's got all the same trappings of presenting evidence and calling witnesses. Once it's gone to hearing, the administrative law judge writes a recommended order. That comes to the Ethics Commission. It is the commission is very constrained in changes it can make to that administrative law judge's order. So it typically adopts the order, and then the commission, as a legislative branch agency, cannot impose penalties. We can only recommend penalties. So we will recommend the penalty to the appropriate officer who imposes it. For most people, the official to impose the penalty is the governor. If you are a employee of the legislature, it would be the House or the Senate. If you are a member of the legislature, we do not have the power to recommend a penalty, but we do have the power to find a violation. And that can be appealed, but once that violation is found, it's with you forever. So if you're filing a complaint, understand that at the end, if the person is not found to have violated the law, they may try to come after you for costs and fees. And if you're a public official who might have a complaint filed against you, I'm sure you're very interested in this as well. It's a really high standard. The person has to show that the complainant acted with malicious intent and knew that there was information that was false in his complaint, or recklessly disregarded the truth or falsity of information. So we've had situations where people misstated facts that they knew were true. And the reckless disregard of the truthfulness of the information, that's kind of a really hard thing to pin down. But the import of all of this is that it's not just a prevailing party standard. It's not just whoever wins the litigation. It is, the courts have said this is a very high standard. And the reason is because you don't want to chill the public's ability to file complaints against its public officers and employees. So moving into the substantive law a little bit. And if you have a question, shout it out. I'll do my best to answer it. So here we are with misuse of position. This is the part of the law that we get the most complaints on, because typically if people don't think something wrong is happening, but they don't know exactly what it is, they will categorize it as a misuse of position. But not everything that is bad or mismanagement or bad government or even violates some other law is a misuse of office. For it to be a misuse of office, you have to corruptly use or attempt to use your public position or resources to get yourself or someone else a special benefit or privilege. So those are the elements. Wrongful intent or corrupt intent means wrongful intent, meaning you're on notice that you shouldn't do it, but you do it anyway. And it's inconsistent with the proper performance of your public duties. So we've gotten complaints that say the city council wouldn't give me my 3 minutes. The chair of the city council made me sit down and wouldn't give me my 3 minutes to talk. That's not a misuse of public position, because it doesn't give any benefit, except, maybe the kind of amorphous benefit of being happy that you don't have to listen to that person for their whole 3 minutes. But these laws are all kind of geared towards preventing the use of public office for private gain, and just, shutting somebody down when you shouldn't, or being tyrannical. We get lots of complaints that say, well, this city official just bosses everybody around, and she has no business calling employees in the middle of the night and threatening them that they'll get fired if they're not there at the clock doing this stuff. Using the stuff in your, on a family vacation, then that is using the resources of your office for personal gain when it was. And this is one area where it's not necessarily always a financial gain. This law has been invoked in cases where the official used his, in fact, it's always been a he so far, but maybe that'll change. I hope we don't have any more cases like this, but where the official has used his position to try and extract sexual favors from subordinates because of the fear that they will lose their job. We have had several cases. Pat prosecuted one or more of them. We had a situation where there was a little road rage incident, and the city commissioner got out of her car, and the other person got out of their car, and he said, "I'm going to call the police," and she said, "Go ahead, I own the police." Another good thing not to say. Really, it's kind of bringing your office into a situation where it's not relevant except to get you some kind of special treatment. So that's, everybody, is always interested in misuse of position, and that's really kind of what it's all about, just keeping the power of your office out of what is essentially personal issues. This is also sort of similar to the misuse. This is the use of insider knowledge. This is, if you happen to find out about, I don't know, some construction that's going to happen, and so you go and buy the land before anybody else gets wind of it. And that was an actual case that happened. In fact, that was a pretty funny case. Funny to me, because I didn't suffer from it at all. But it was a great case because this somebody that worked in like a planning department in a city got together with a lawyer, and the planning guy put together all this knowledge that he had, and it was all public record, okay? So it doesn't have to be not public record. It was all public record, but there was a little piece of information here and a little piece here, and this guy pulled them all together and figured out how to make a big land deal out of it and sell property to the city, I think is what was going to happen, with the help of this lawyer. So in the end, all of this came uncovered, came unraveled. It was one of, I can't remember how big the fine was, but it was one of the biggest fines in the commission's history. And the lawyer ran off with the planning guy's wife. All right. This is so exciting to me that I really want to spend a couple minutes on it. Y'all might recall last November there were a few constitutional amendments on the ballot. It seems so long ago. This was one of the few, maybe it was the only one, that this was the only amendment. I mean, several of them were, putting vaping together with offshore oil drilling and all of that. But this was a single one. This was Amendment 12. It, among other things, it puts a 6-year revolving door prohibition effective an odd date, December 31st of 2022, for a lot of public offices. And more pertinent to me and what I'm concerned with at the commission at the moment is effective December 31st of 2020, there will be a prohibition on abusing, that's the word that's used, abuse, your public position to obtain a disproportionate benefit for yourself, spouse, child, employer, in certain businesses that you have particular kinds of relationships with. So that is pretty interesting, and from watching the videos of the Constitution Revision Commission's meetings and reading some of the materials, it seemed pretty clear to me that they were looking for something. They don't feel like the public trusts its officials, and they were looking for something in addition to the laws that we already had. So part of this requires that the Ethics Commission must define by October 1st the term disproportionate benefit. We have to figure out what is a disproportionate benefit and adopt that by rule. And you local government types are lucky ducks because you don't have to deal with the Administrative Procedures Act for the most part like state agencies do. It is Byzantine in its complexity. I thought the ethics laws were complicated, but the APA is very complicated. So we have to adopt this by rule by October 1st, and we also have to prescribe the requisite intent that it would take to violate this constitutional provision. And then after that, the legislature will enact implementing law to establish penalties for violations. So this has been very interesting and very challenging for us. We held several rule development workshops over the spring, and we promulgated a draft rule that we took to our last commission meeting on June 7th. And we had many, many lobbyists there representing county commission, League of Cities, Association of Counties, not liking the rule we promulgated at all. Sheriff's Association was there. So our commission asked us to have a workshop, and I'm kind of like dead man walking, so because I'm not going to be there for the exciting climactic finish of all of this. So I haven't been in the loop, but I think what they're going to do is have another workshop at our next meeting, which will be in July. And if they don't make any changes to the rule, they can adopt it at that time, or if they make changes, they can bring it back in September. But we have to have it done by October 1, and I think the rationale for them setting the October 1st date is that the legislature will start, this is an even-numbered year, so the legislature will start in January, and they will start their committee meetings probably late September or in October. So that's probably the rationale. If you are interested in any of this, and I hope you will be, you can follow it on our website, on the opening page of our website, which is ethics.state.fl.us. On the opening page, it has announcements, and you scroll down, and it'll give you a link where you can go to see the draft rule, all of the comments we've received. Oddly enough, guess who else doesn't like it? Builders and developers. got some letters from them. So, so it'll be fascinating to me to watch. And I'll just give you a little tidbit of what the rule is. It's pretty simple. It says, disproportionate benefit means a benefit, privilege, exemption, or result not available to similarly situated persons. And it goes on to say that in deciding whether there's a disproportionate benefit, the commission will look at the size of the class of people who will experience the benefit, the nature of the interests involved, the degree to which all members of the class are affected, and the degree to which the public officer receives a greater or more advantageous benefit when compared to others. And the requisite intent in the draft rule says the person acted or refrained from acting with knowledge that his or her action or failure to act would result in a disproportionate benefit. I'm biased because it's our staff that did it, but I thought it was a pretty good rule. But we'll find out what actually gets enacted in the end. Yes, sir?
Question. So who has the right to enforce this? Does that fall exclusively to the commission or private?
Well, that's a good question, and the question is who will be enforcing this constitutional provision? And, you know, it is a good question because we have general authority over Article 2, Section 8, and this is included in Article 2, Section 8, so I feel confident that it will be the Commission. And as I said, we're a legislative branch agency. We're not an executive agency, so in truth, we don't really enforce anything. Our mandate is to investigate and report on allegations of breach of the public trust. So we issue our final report finding a violation or not finding a violation, and in most cases recommending a penalty, but in some cases, as I mentioned, nobody enacts the penalty, but it doesn't matter because once that person is found in violation by the Ethics Commission, unless it's reversed on appeal, they're stuck with that. And a good example of that is David Rivera in Miami from the State House. After lots of litigation and appeal and whatnot, the administrative law judge found him in violation of several of the ethics laws and recommended a fine, which could be done because he's no longer a sitting member of the legislature. So there is the power to recommend a fine. So the House has never imposed the penalty, but that the Commission's finding of a violation was appealed to the district courts of appeal and upheld, and so that violation it stays there permanently. All right, nepotism, fun with relatives. If you're a public official who has the ability to hire, appoint, promote, or to recommend hiring, appointment, or promotion, you can't do any of those things with respect to one of your relatives. And really, why would you want to? I can't think of any of my relatives that I would like to hire, promote, or appoint to anything. So, in looking at this question, it's important to know who actually has the authority to do the hiring. Because if you don't have the authority to do the hiring and someone else does, it's perfectly fine for that person to hire your relative. And we have a great example of that right here locally. We had an opinion. Thank you, Bob. It's 18-17. I will say our website is a great resource. If you want to ever go on and peruse our opinions, they're all on there. This is CEO 18-17. This was the Key West Utility Board chair, and his son was being considered for a position with the Key West Utility Board. And the commission, the Ethics Commission, said that he could be hired because the hiring was done by the general manager. It was not done by the board itself. However, of course, the chair had to stay out of it because if he leaned on somebody to make sure his son got hired, that could be not only a nepotism violation, but it could be a misuse of position, if he tried to arm twist somebody. So it's critically important to know who is vested with the hiring authority. And if you are vested with the hiring authority And when I say vested, I mean vested by statute, charter, ordinance, the whatever policy establishes that agency. If you're vested with that authority by any of those things or by delegation, hey, I am the general manager of this department, and I'm going to make Pat Gleason, who's my deputy, I'm going to put her in charge of all the hiring. Well, now guess what? I can't hire any of my relatives anymore, and then Pat can't hire any of her relatives either. So it's like flypaper. Once you are stuck with that hiring ability, even through delegation, then your relatives are out of it. You can't just kind of hand it off because this happens sometimes. Well, my son's under consideration for this position, so even though I'm the person that's in charge of the department, I do all the hiring. In this one case, I'll let my number two do the hiring so that my son can receive consideration. That doesn't work. Hiring authority is like flypaper. It sticks to you, and you can't hand it off just because you want a relative to be able to compete for the job. Something a lot of people don't understand about the nepotism law is that it does not prohibit relatives from working together. So let's say the department director who does all the hiring hires you and then hires your husband. He can do that. You can work together. You can supervise one another. You can discipline and terminate each other's employment. All of these things. I know. I see grimacing, but yeah, that's the fun part. Also, there's a grandfathering. So, and I used to work for the Sheriff's Association when I first got out of law school. And we had a number of sheriffs who had married office staff. They had married their assistants or whatever. And that happens, but nobody has to leave. Nobody has to quit their job or get fired. But that person is frozen. They're never going to be able to get a promotion as long as they are in that relative status because they cannot be promoted. So what is a relative? A relative, there are 3 different definitions of relative in the ethics laws because why have one if you can have 3? This one is spouses, parents, children, siblings, uncles and aunts, first cousins, nephews, nieces, parents, children, siblings in law, step-parents, step-children, and step-siblings, and half-siblings. Now, you would think that this would not come up very often, but people are constantly trying to figure out who their relatives are. So we have an opinion that says your spouse's stepmother is not, even though your stepmother would be within the class of relatives, your spouse's stepmother is not. We have, was that one of yours too? Yeah. We get a lot of business from Monroe County, actually, you know. It's good. It means somebody's paying attention and trying to keep everybody out of trouble, which is a great thing. Your stepdaughter is covered, but if you divorce her mother and she's not your stepdaughter anymore, she's no longer a relative. I thought that was harsh. You know, it's kind of like, you're out of the nest, sorry. And your wife's brother is your brother-in-law, but his wife is not your sister-in-law. So if you're wondering about these this is why I went to law school. If you're wondering about these nuanced questions and it comes up, let us know because we'll try to work that out for you. There are exceptions to the nepotism law for boards that don't have land planning or zoning responsibilities in cities under 35,000. There are certain exemptions in the state university system, which is why at one time there were so many Bowdens working for FSU. District school boards have a different set of nepotism, which I'll talk a little bit about in just a few minutes. There's some for volunteer emergency providers, and of course legislative pages and messengers. The prohibition extends to collegial bodies, which means that if you sit on a county commission or city commission, your relative cannot be appointed to any position, even if it's an unpaid position, and even if you abstain. So be aware of that. Some people don't appreciate that.
That's appointed by the board.
Appointed by the board, right. And I mean, we worked on it a little bit legislatively one time, because somebody said, okay, so if I'm a board member and all my colleagues hate me, and so does my relative, then my board could get me in trouble by voting to appoint my relative. and then I would be the one that, had to bear the burden of an ethics violation. But that claim was made in the course of a complaint, and so we thought about it, but it seemed like such a rare and unusual potential that nobody ever really pursued legislation on that. So I said I was going to talk about school districts, so I am. There's a special anti-nepotism law in Chapter 1012 for school districts, and the way it was is school board members could not employ or appoint a relative to work under their own supervision, and the Ethics Commission really didn't have any jurisdiction because it wasn't in the ethics laws, and it didn't specifically give us jurisdiction, so we didn't really have anything to act on. But in this last legislative session, chapter law, I'm sorry, not last session. This is another weird date thing. This is the 2018 legislative session. They passed Chapter 2018-5 to be effective July 1st, 2019. So as of July 1st, the prohibition will be extended to school superintendents, and the commission is given jurisdiction on these cases. This is really interesting, and we've already received a formal opinion request. So probably at our July meeting will be coming out, because it appears that there's, or I think what they say in the request is that school superintendents do the recommending and the school board does the hiring. So that'll be something to be looking forward to for you school board folks that want to see that law fleshed out a little bit. The 2018-5 also makes a change in the revolving door prohibition, which I'll talk about in a little bit, but it basically extends the revolving door prohibition, which is currently 2 years, to appointed superintendents of school districts. I don't know what the superintendents out there were doing, but somebody didn't like it, and so the revolving door prohibition has been extended to them. This is one of my favorite topics because I like gifts. Thank you very much. There are a lot of gift laws out there, and it seems more on the horizon every day. This one is a kind of a specialized gift law. It was enacted in 2013 when there was a lot of ethics legislation passed. It does not apply to anyone who doesn't have to file financial disclosure. It only applies to people who have to file disclosure. And it says that political committees are prohibited from giving, and people who file disclosure and their parents, spouses, siblings, and children are prohibited from knowingly accepting any gift from a political committee. For purposes of this law and this law only, gift is defined as anything of value not, quote, primarily related to contributions, expenditures, or other political activities authorized under Chapter 106. I've never run for office, and I'm not that well versed in campaign finance law, so I'm not exactly sure what primarily related to political activities is supposed to mean. The impression I got from watching this legislation get passed was that there was a concern that politicians were using these political committees as supplements to their own income and bank accounts, and they wanted to put a stop to that.
Joyce, can you answer that? She's our election supervisor.
Okay, so the election supervisor is going to explain to us what primarily related to other political activities authorized under 106? Or not? She asked that the beginning of the sentence be read again. For purposes of this law, a gift is defined as anything of value not, quote, primarily related to, unquote, contributions, expenditures, or other political activities authorized under Chapter 106. So I was just wondering what those political activities would be that they're referring to. Well, thanks. That's very helpful to me personally. And in case it didn't pick up on the tape, I mean, what I kind of am hearing is that things that are given to facilitate activities like a meet and greet, designing a website, those kinds of things would be considered political activities. So if money is given in furtherance of that, that's not a gift. But if money is just given so that you can, I don't know what, go on vacation, then that could violate this. Well,
On their campaign financial forms.
right. Anything you get in your campaign has to be reported on your campaign finance reports. Well, whatever they were thinking, they were very serious about it, because if you violate this law, in addition to the penalties authorized under Chapter 112, which I should have mentioned when I was talking about complaints, can include removal from your position, fines of up to $10,000, public censure and reprimand. In addition to all of those, if you violate this, you can get a penalty of up to 3 times the value of the gift. So it was on their minds, but I can't think of any cases, any complaints that we have had connected with this. I'm kind of working from some of that specialized gift law, and these are kind of some overarching gift laws, and then getting to sort of the narrower gift laws as I go along. And when I say overarching, these 2 gift laws apply to everybody, and they're pretty intuitive. They're not limited to certain positions. They're not limited to people who file disclosure. They apply to everybody. And the first one, 112.313 paren 2, it says you can't solicit anything of value, doesn't use the word gift, anything of value to the recipient with the understanding that it would influence you in your public office or employment. So this is basically bribery. I mean, it's like the next best thing to bribery. And we actually get very few complaints on this particular law, because by the time somebody is that far gone that they are soliciting things or accepting things with the understanding that it's going to influence them, they're usually looking at criminal prosecutions and not ethics commission prosecutions. The other one, 112.313 paren 4, is a little bit less specific. It says you and your spouse and minor child are prohibited from accepting anything of value, again, the word thing of value, not gift, when you know or should know under the circumstances that it's being given in an effort to influence you. We've got some elected officials here, yes? Yeah, I know we got a couple. let me ask you this. Did you have more friends the day before you were elected or the day after? Well, perhaps we should exclude State Attorney Ward. Typically, elected officials tell me that they find that their phone calls are returned much more quickly after their election, that people suddenly realize how beautiful they are, how smart they are, how talented they are, and how funny they are after their election. And this law kind of recognizes that people are going to try and curry your favor. So if you know or should know under the circumstances that that is why this gift is being given to you, then you should not accept it. The courts have said, in fact, that the law requires the official to ask, why is this being given to me? So I will say this, sometimes, not here, of course, because you are all very humble, but sometimes a public official might say, well, Verlindia, I mean, look at me. I am smart. I am funny. I am beautiful. People love me. How am I supposed to know that they're giving a gift to curry favor? Well, some factors the Commission has looked at in its opinions are the proximity in time of the gift to some event of significance to the donor. If the vote is tomorrow and the gift is today, that's something to think about. The size and value of the gift. If it's something that is really kind of shockingly grandiose, that's a clue. And the proportionality of the gift to the relationship. If it's a gift that's coming from your childhood friend, it would be less likely that it's being given in an effort to influence you than if it's being given by somebody who you really don't have any gift-giving kind of relationship with. So those are things to look at. But here is kind of the true gift law. It's the word, it's the law that actually uses the word gift. It's the original gift law. And these laws, it's all under 112.3148, but there's a number of laws, subsections under that. And they apply only to reporting individuals and procurement employees. Procurement employees, you don't have to worry about because those are state people. Reporting individuals are people who file financial disclosure. If you do not file financial disclosure, you can take a nap now, and I will let you know when it's time to wake up again, unless you want to just like pay attention just so that you know how everybody else is doing and what they're supposed to be doing. And I will say this, in addition to not having to deal too much with the Administrative Procedures Act, you're also very lucky because you don't have to deal with some much more onerous laws that apply to state people respecting gifts. They're very, some would say draconian, some would not, but they are much more significant than the laws that you have to deal with. So, and I will say this, if you serve on any state boards, which sometimes local people do, keep in mind that some of these other laws might apply to you, but I'm only talking about local officers and employees today. But if you serve on any state boards, there might be a whole nother set of gift laws that applies to you. Why are there 4 fingers up there? There could be a joke there, but I'm not going to tell it. It's because I have 4 things to tell you that will, if you can remember them, will help you out a lot. One is, you can always accept a gift of any value from a relative and you never have to report it. Now, I will say there's one caveat to that. If it's a bribe, you can't accept a bribe even if it's from a relative, okay? So if it violates one of those ones we just talked about a minute ago, like it's given with the understanding that you're going to use your public office in their favor, no, don't take it. But if any other kind of gift, you can always accept from a relative and you don't have to report it. Now, this is the second definition of relative. It's big. I'm not going to read it to you. It includes practically everybody and all the people who live in your household. So if you're living with a boyfriend or girlfriend, it includes them. It also includes people that you have announced that your fiance and anyone you've announced that you're going to be married to. It does not include your friends, your neighbors, or your boyfriend or girlfriend if you're not living with them. So to help people remember this, I told you I like gifts, and I tell people, if my husband gives me a nice Rolex watch, it's from a relative and I don't have to report it. If my boyfriend gives me a nice Rolex watch, I do have to report it, okay? So he's not a relative. So it was a joke. I don't really have a boyfriend. And if I did, you think I would tell you when it's being tape recorded? Of course not. So, but people are often surprised that the definition of relative does not extend to boyfriends and girlfriends, but it does not. Number 2, you cannot solicit gifts from a lobbyist of your agency, and I'm going to talk in a minute more about what a lobbyist is, or the partner firm or employer or principal of a lobbyist, or from a vendor, if the gift is for your personal benefit or the benefit of another reporting individual or any member of their immediate family. There is no dollar threshold on this prohibition. You cannot ask a lobbyist or a vendor of your agency for a cup of coffee. And I will tell you, it was very sad to me, and I can't remember where this community was, and I don't like to name names anyway, but it was a community where it was a small community, and there were a couple of staff promotions in the ranks, and everybody was very happy about that, everybody in the local government arena. And they wanted to have a party to celebrate this. Unfortunately, they did not have any money to spend on said party. So somebody had the bright idea of soliciting the money from city vendors. And they all got in trouble for it. And the mayor was, of course, mortified. So somebody raised it, the issue. They all went, oh my God. They sent all the money back. By then, someone had already filed complaints. And I think the mayor ended up paying a fine for doing that. And it was sad because they recognized immediately when it got raised that they should not be doing that. But that is an object lesson in not soliciting gifts from vendors. You cannot accept gifts worth more than $100 from a lobbyist of your agency or the partner firm, employer, or principal of a lobbyist, or from a vendor. Reporting will not cure that violation either. So I always say these lobbyists of your agency or the partner firm, employer, principal of a lobbyist, or vendors, we call them prohibited donors. So when I say prohibited donors, it includes that whole group. And then if someone other than a relative, because you don't have to worry about relatives, or other than a prohibited donor, gives you a gift worth more than $100, you can accept it, but you have to report it. And the reporting is on a form that you can get off our website, and it has to be filed no later than the end of the quarter following the quarter in which you receive the gift. And this statute applies even if the gift has nothing to do with your public role. So if your neighbor gives you his car, it's worth more than $100, you would have to report it. If your friend lets you use their beach house for a week, it would be worth more than $100. I'll talk about valuation in a minute. And you would have to report it. People, it's really, because it's not particularly intuitive, people have a hard time understanding that even if it has nothing to do with your public office or employment, if you get a gift worth more than $100, if you're a person who files financial disclosure, you must report it. I'm going to focus for a second on the prohibition on gifts worth more than $100 from lobbyists. You can't accept anything worth more than $100 from a lobbyist of your agency or any other prohibited donor, including vendors. And we just had a case at our last commission meeting on June 7th where we had a city mayor who accepted a variety of gifts from people who were lobbyists at the agency and ended up paying a $5,000 fine for it. These gifts cannot be accepted directly or indirectly. Everyone pretty much understands accepting a gift directly, but sometimes people are a little more confused about what is meant by an indirect gift. So I always say you have to look at who the gift is really coming from and who it's really directed too in looking to see whether something is an indirect gift. So when you're looking at where the gift is really coming from, you're looking at if I want to give someone a gift, I want to give a city commissioner a gift, but I can't because I'm a lobbyist of the city. So I give it to my husband to give to the city commissioner. That would be an indirect gift from me because it's really coming from me. And then when you look at who is the gift really directed to, who is really the consumer of the gift, that's where you look at the gift is coming from, it's going to a third party, but it's really directed at the official. And an example of this is when the lobbyist says to me, Verlindia, you're a city councilwoman, I'd like to buy your dinner. It'll be, less than $100. It'll be $55, and bring your husband. I'd like to meet him. So now, what have I received? Have I received one $55 dinner? No, I've received two, because the dinner is consumed by my husband, believe me, but it's really directed so that the lobbyist can have dinner with me. So you have to think about who's the gift actually coming from and who's it actually going to. So we have an opinion from back in 2006. It's 2006-27. I think I cited in your materials because I love this opinion because I think that this is the coolest thing. In Miami Beach, they have this art festival that they patterned on a Swiss art festival called Art Basel, B-A-S-E-L. I'm not sure I'm saying it right. Art Basel. And so the city wanted to send a city commissioner to Switzerland to experience this festival. And I thought, what a great job it is to be a city commissioner in Miami Beach. This is, you have to go to Switzerland and see this festival. Okay, so, and they said, you can take your wife with you. Well, the trip for the city commissioner to Switzerland was not a gift. He was performing duties in the service of his city. But the trip that the city paid for his wife was a gift, an indirect gift to the city commissioner. He could accept it, but he had to report it. And this illustrates another good point. A lot of people don't think it's possible for your agency to give you a gift, but that is not true. Most of you, I don't know how to say this the right way. If you're not in the upper echelons, it probably doesn't happen that much. But agencies can give gifts, and it often happens in the context of tickets. So an agency builds a stadium or whatever, and or makes some kind of contract with a sports team. And as a result of this contractual relationship, the city has X number of boxes or X number of seats in this theater or whatever. And then the city comes up with some kind of way of distributing those tickets. And so if you are the recipient of one of those tickets, you received a gift from the city. And depending on the valuation of it, you may have to report it, even though you can accept it without any problem. Now, since you can't accept anything from a lobbyist, you need to know what a lobbyist is. I've advocated for years of tattooing or branding lobbyists so that we'll have some easily recognizable system for recognizing them, but I haven't been very successful with that, so we'll just have to go with the definition. It's anybody who gets paid to seek the influence of you or your agency or has done so within the last 12 months. Lobbyists, short version, I'm always trying to think of ways, little acronyms or whatever to help people remember stuff. I call lobbyists people who get paid to persuade. Okay, if this person, whether you think of him as a lobbyist, like a Tallahassee lobbyist, like really smooth with loafers and, designer belts and whatnot, or he's just a guy that shows up because he works for a company and he wants to get a permit or whatever. If he's getting paid to represent a company or an entity before you or your agency, he or she is a lobbyist. Now, who's not a lobbyist? People that just show up to represent, Joe Citizen. When Joe Citizen walks into your office and says, I think this dog leash ordinance is a terrible thing, then he's not a lobbyist. Why? He's not getting paid to do that. He's just doing it because he's a citizen. So salesmen, employees of companies trying to get you to do stuff, lawyers who appear before you, all meet the definition of lobbyist.
So does that include, like, lobbyists who may be working pro bono for a nonprofit organization?
Oh, good question. Does that include people who are working pro bono for a nonprofit organization? It would not, because they are not being compensated for that. Now, that leads to a question that I don't really know the answer to because it hasn't come up. What if you're a lawyer for a law firm and your law firm has a pro bono component? In other words, every lawyer here is going to get paid for 40 hours a week, but 2 of those hours have to be working on pro bono cases. So you're getting paid, you're getting compensated, but you're not getting compensated by the person whose interests you're representing. That hasn't been asked yet, but if you are not being compensated for the representation, you are not a lobbyist. Now, I will say this happened a long time ago, and it was in the context of a complaint where the person said, well, it's true that I was this individual's lawyer, and I billed him for, hundreds of hours over this, past 6 months period for doing but I didn't bill him for this over here where I was representing. And the commission, and this was in the context of a complaint, so I don't know how much precedential value it would have, but the commission really basically said, he's your client, he was paying you, you were representing him. You can't just say that you were representing him here and not here, and they did not buy that argument. So I would say that if you're being compensated, they're probably going to be considered to be compensated for all purposes. Ooh, sorry about that. Whoever's listening to the audio is going to get a eardrum broken there. All right. So we know what a lobbyist is now. What is a gift? The term gift is defined in the definition section of the code, and the general definition is a gift is anything that you get that you don't give equal or greater consideration for within 90 days. So you have a lovely 90-day window to make something not a gift anymore. In addition, if it's a gift that is over a limit, so it goes over the $100, if it's from a lobbyist, you can accept it. You have that 90 days to pay it down. You can give the lobbyist enough money so that if it's a $120 gift, you can give him the $20 to bring it down to $100, and then it's below the threshold. So, or if it's a gift that you don't, I see a confused look. So you can pay it down. So you can't accept a gift worth more than $100 from a lobbyist. Okay? So if I give you a gift that's worth $120, you can't accept it. But if you give me the $20, now you've only got a gift that's worth $100. Okay? Now, the trick to that is you can accept it, okay, but guess what? I'm the lobbyist. If it's worth more than $25, I'm supposed to report it. Sometimes they don't, but people who know what they're doing, like Disney, they file those reports. They know that if they give somebody, a reporting individual, a gift worth more than $25, even if the person can accept it, it has to be reported by the lobbyist. So the goal of all of this is to get the information out there about what gifts public officers and employees are receiving, and to prevent them from receiving gifts in excess of $100. But in all of this, again, you have 90 days to either pay it down or pay it all. I mean, I've had people that said, "Oh my God, I just realized I shouldn't have got this. I'm just gonna pay the person the value of the gift completely." So I always tell people to keep their receipts if they go out to dinner with lobbyists, because we've had more than one complaint where people see a public official eating dinner with a lobbyist and they assume that that lobbyist has picked up the tab. And and I have a few things that I'm not going to read the whole list of things that constitute a gift, but a few things that people get tripped up on because they don't realize that it could be considered a gift. One is prizes, like door prizes. That's a gift. Most of the time you're going to be able to accept it, but it's a gift. It's something you got that you didn't pay for. Free publicity can be a gift. And I don't mean the publicity that calls when you do something dramatic and the newspaper picks it up. These are cases where people have been given public service announcement spots on TV, public service announcement, little videos, trailers in front of movies. Use of property can be a gift. If you stay in somebody's house, that's a gift. And travel other than travel paid for by your agency for official business can be considered a gift. What's not a gift? Your salary. Okay, we all know that, right? Things that are associated with your activities as a corporation or organization. Campaign contributions aren't gifts. Plaques and certificates aren't gifts. Gifts from organizations promoting the exchange of ideas between officials like the National Association of Attorneys General, or in my case, the Council of Governmental Ethics Laws, if they were to, or yes, plaques and certificates, again, not a gift. So there's a whole list of things. And I think I've already mentioned it is possible to get a gift from your own agency. So let's get to valuation real quickly. Yes, sir. I'm sorry.
Is there some sort of temporal component? Did you accept a gift of, let's say, $50 2 or 3 times?
Oh, that's a good question. And the question is there a temporal component of accepting the gifts in sequence or in some kind of serial fashion? So if you get $50 today and $50 tomorrow and $50 the next day. And the answer is it depends. My predecessor used to always say it depends on the provable facts. So people always say, well, what if I get a golf club and then next week I get another golf club from the same person and they keep giving me a golf club until I've got a whole set of clubs? My answer is you've been given a set of golf clubs. And if a complaint is filed against you, you know, the commission sits in a quasi-judicial fashion, so they may, I don't know what they may do, but I think it is fairly likely that they would find that you had been given a set of golf clubs. If you are given a ticket today for today's ball game and then a ticket tomorrow for the next ball game until you've got a whole set of season tickets, you've been given season tickets. So on the other hand, you may have a factual situation where somebody says, look, I've got tickets to Disney World and I can't use them. Here you go. Have some tickets to Disney World, and you use them and fine. And then next month they said, well, you know, we were planning to go to Disney World, but my wife broke her leg, and now we're not going to. That, there's no, you have to kind of look at what is intended to happen, because there it's clear that, you know, they were not intending to give you sets of tickets. But in the case of, you know, the golf club case, I think that would be a pretty clear indication that the intent was to give you the whole set of golf clubs. So it does depend, but, and there's no rule or specific formula for serial kinds of gifts. It all depends on the individual situation. But I always tell people you don't want to be the test case on that. So if there's no more specific way to establish a valuation of the gift, the value is the cost to the donor minus taxes and gratuities. And the most likely gift that people, I think, are likely to receive is lodging in a private residence, where somebody lets you use their beach house or their mountain cabin or whatever. I will tell you the value of that is $44 per night. So if you stay 2 nights, you're under the $100 limit. If you stay the 3rd night, you're over the $100 limit. And that is arrived at by per diem minus meals. So it's $80 minus 19 minus 11 minus 6, $44.
What if they cook for you too?
Well, if they stay in my cabin and I cook for them, then it takes away from the value of of the experience. Here's a couple things that it says in the law you can accept. We've already talked about gifts from relatives and gifts from non-lobbyists. You can accept gifts on, quote, on behalf of charities or your agency. Be careful about that, because the law says you can accept a gift on behalf of the charity and retain it for no longer than it takes to get it to the charity. That's all well and good. But a charity is only a 501c3 charity. It's only an actual charity. So you kind of have to be careful of that. And it's not just the Verlindia Doss, Pat's laughing over here, the Verlindia Doss needs some new shoes foundation. So I had a guy call me one time and he said, do I have to report these turkeys for my Christmas dinner? And I said, I don't know what you're talking about. And he said, well, my turkeys for my Christmas dinner. Well, what had happened was a lobbyist of his agency had given him a lot of turkeys so that he could put on a turkey dinner, which he claimed under he didn't say these turkeys are somebody else's turkeys. No, it was my turkeys that I am giving to all of you for this Christmas dinner. And he wasn't even allowed to accept the turkeys in the first place. And so he was really surprised about that. It was not good. So careful with that. And also gifts, you can accept gifts on behalf of your agency. What I say about that is, just because you keep it in your office doesn't mean it's a gift to your agency. And I will use an example of somebody who called me and said they had been given a very attractive leather motorcycle jacket, complete with patches and whatnot, and by a motorcycle organization. And they were not the motorcycle jacket type, and they wanted to put it in a shadow box and frame it and keep it in their public space. And I said, that's still a gift to you. You know, once you've got it and you have control over it and you can do what you want with it, it's a gift to you. So just because you keep it in your office doesn't mean it's a gift to your agency. Honorarium and honorarium event-related expenses are kind of related to gifts, and a lot of the same principles apply. The law only applies to reporting individuals and procurement employees. The definition of lobbyists and the concept of prohibited donors carries over. It's important to know the difference between an honorarium and an honorarium event, because you're prohibited from accepting honoraria, whereas you might not be prohibited from accepting honorarium event-related expenses. An honorarium is what I'm not getting today, which is payment for making a speech. An honorarium event is the function that you're invited to go to. Public officers and employees, reporting individuals cannot solicit an honorarium for giving a speech or a talk about their own public duties. So I could not solicit an honorarium for what I'm doing today. Now, the law is silent about whether you could accept one if it's offered, Dennis. But I would not recommend it, because if you are there in your public capacity speaking about your public duties, I think you were asking for trouble if you solicit or accept an honorarium. You can accept honorarium event-related expenses, which are travel, lodging, food, and registration costs, as long as they're reasonable and actual, from lobbyists, non-lobbyists, whoever. I always recommend that you keep evidence that you were invited to speak. You cannot accept, you can't accept an honorarium under any circumstances from a lobbyist firm, partner, principal of a lobbyist, or vendor doing business with your agency, even if it's not related to your public responsibilities. I just went over the event-related expenses. It has to be reasonable and actual. If you're invited to give a speech in Hawaii on Monday, you cannot stay until the following Monday. You have to come back. Lobbyists who pay honorarium event-related expenses have to provide a statement to the individual within 60 days, but even if they don't, the individual has to report them by July 1. And I'm getting close to the end here, so I'm going to 20 minutes. I may have to skip over a couple things because there's some new stuff about revolving door that I want to tell you about, and I do want to tell you a little bit about financial disclosure. Financial disclosure is due July 1st. I will give these tips. File on time. Read the instructions. Don't just copy over last year's form. Your financial circumstances may have changed. And for heaven's sake, don't put your social security number, bank account numbers, credit card numbers on there. If you file Form 6, your forms are going to be posted on our website, and we spend a lot of time reviewing and redacting the forms. But we're human, and I live in fear that, somebody's social is going to get out there. So make sure you don't put that stuff on there. For Form 6 people, and a lot of this applies to Form 1, don't leave out a box. Don't leave something off, because that's the first thing disgruntled citizens look for, is something that's just omitted. Your net worth does not equal your reported assets minus your reported liabilities. It means all your assets minus all your liabilities. If you Form 6 people, you don't have to report assets that are worth less than $1,000. So your total assets should be more than your reported assets. This is very hard for people to understand, that it's important to know what you own and how you own it. Well, what do you mean by that, you say? What I mean is, you might own something jointly, or you might own something jointly with right of survivorship. It's a different kind of ownership. So your bank account with your spouse is probably going to be joint with right of survivorship, meaning if you die, your spouse gets everything that's in there, and meaning that your spouse could clean it out at any day. If you just own it jointly, if you just own property jointly, they can't necessarily do that. So it's important to know how you own things, because it involves how you report them. If you have an asset that you own jointly with someone, you only report the part of that asset that you own, 50%, 30%, you only report that share of it. If you own it jointly with right of survivorship, or like most homes are owned with spouses by tenancy by the entirety, you own the whole thing and you would report the entire value. Leased vehicles, you'll probably be surprised to hear this, they're an asset and a liability. And if you want the calculation, how to calculate that, it's in CEO 14-18. On our website, we have a whole compilation of commission opinions in the bottom line, so that people can look at them. They just apply to the financial disclosure, and so that people can get some guidance on all of this. Here's one nobody thinks about. Loans to campaigns. If you loan yourself money for your campaign and you expect to get paid back, hence the use of the term loan, what is it? An asset. It's an account receivable. So if it's more than $1,000, and we get complaints on that, people, all of you elected officials know, when you run for office, people are out there like this. They're scrutinizing your information. All right. Yes.
So, having control, authority, responsibility, but the trust is the owner, the physical and legal. Where does that leave a person?
That's a good question. You're the trust. What if you're the trustee of a trust? I'm sorry? You're the successor trustee, or even if you're the trustee of it. If you're the trustee of a trust, you don't own that. You're holding it for somebody else's benefit. Am I right? Yeah, you're holding it. You're not supposed to go out and spend it on yourself. So you wouldn't list that. If you're the beneficiary of a trust, then you would list that as an asset. Yes. That's a good question. Okay. For income, if you're a Form 6 filer, you can attach your tax return. I would not recommend it. Your tax return has your Social Security number on every page. You're much better off, I think, listing your income. It's also much more informative to the public. If you're a Form 1 filer, you have two ways that you can file. Comparative versus dollar value. Comparative, you have to figure out percentages of your income and your net worth. Dollar value is much easier, and it doesn't require you to do those calculations. But whatever way you choose, you have to choose one way and stick with it. You can't do dollar value for some and comparative for others. Form 1 filers, unlike Form 6, don't have to list their actual income or the value of their assets or liabilities. They just have to list what they are. Intangible personal property, and the same is true for assets for you Form 6 filers. Understand this when reporting intangible personal property. If you have an IRA or if you have a brokerage account with Merrill Lynch, those things are not your asset. They are not your intangible personal property. Your asset or your property is the product inside those baskets. If you have a Merrill Lynch account with a mutual fund and a couple of stocks, those stocks and mutual funds, those are your assets, not your Merrill Lynch account. So you would only report them if those individual things meet the threshold.
So, like a mutual fund has many components within it. You just identify the mutual fund, not the 20 different products within that mutual fund?
Correct. And the question was, a mutual fund has a lot of different products in it, but you just identify the mutual fund. That's true, because the mutual fund is what you bought. You bought the mutual fund. You didn't buy the little things that are inside it. They may not even be there next year. But you did not buy a Merrill Lynch brokerage account. You bought the stocks and bonds and mutual funds that are in that account. So just remember, those are your assets and your personal property. CPAs and attorneys can fill out your forms for you, and if you've given them all of your information, if they make a mistake, you will have some protection from it. I call that the Attorney and CPA Relief Act. Bring us more business. Yes, indeed. What happens if you don't file? Well, in some places like Monroe County, the supervisor of elections will be knocking on your door and saying, get your form in. So, and you get filed. If you don't get it in by September 1, you get a $25 a day fine to a maximum of $1,500. If you're employed by a government agency, we can have them withhold your salary to pay that fine. We can garnish your wages, and we have a 20-year statute of limitations. That's longer than, I don't know what, longer than practically anything, except murder maybe. And if you don't file at all, we're required to initiate a complaint against you. And the only penalty is removal from your position. But guess what? All things must come to an end. And in January, oh, it's not the end of the presentation. Don't be that happy. In January 1 of 2022, Form 6 filing will be completely online. There will be no more paper forms. January 1, 2023, Form 1s will be all online. And the supervisors will be out of the business of collecting it. It will all go to the Ethics Commission. We'll have the ability to really make sure everybody, has the instructions right in front of them. And so if it works, it'll work great. I meant to say when it works, it will work great. So we're pretty excited about it and a little bit terrified. All right. This is a picture of me and my husband canoeing together. Conflicts of interest are designed to keep public officers and employees from being tempted to disregard their responsibilities in the public venue. This one is kind of a specialized conflict law. It basically is saying that if you're offered a job, you have to, or a promotion, it has to be under the same circumstances that other people would get it. And this came about when you had some public officials who, in a lot of cases, were getting jobs with universities, but they didn't really have any qualifications for that. You can't sell things to your own agency, and if you're and you can't buy things from your own company or from a relative's company for your agency, even if it means getting it cheaper. The flip side there. You can't have a contractual or employment relationship with a business entity or agency, even if it's a public agency, regulated by or doing business with your own agency. So, for example, I could not get a job, even a menial job, working for the company that sells paper to the Ethics Commission. That's pretty intuitive for most people. You also can't have any employment or contractual relationship that creates an actual conflict, meaning it tempts you to dishonor your public responsibilities. Not that you couldn't withstand that temptation, but the whole idea is to just like get you out of the loop altogether. So these kinds of things often come down to situations where a person wants outside employment, and the outside employment would result in their being able to the outside employment would be a business that they could refer business to in their public capacity, or they would review their own work in their public capacity. For example, you couldn't be, if you were in the planning department, you couldn't be an architect who submitted plans to your own department, those kinds of things. We get more questions about this statute than any other because it's, you know, the outside employment kind of situation. So we get lots and lots of questions from public employees who, of course, are not paid enough by their public employers and have to go out and get part-time jobs. So,
Can I ask a question on that?
of course.
I saw that you had to be an employee, but is there also an issue if an existing employee, public officer, takes a position on, let's say, an association or a board who either advocates or goes against certain actions that the government is taking, like let's say the Builders Association or something like that. Is there anything related to that?
That is a really good question. And the question is, what if you're a public officer or employee and it's not an employment relationship, but you take a position with some kind of organization that has an interest before your board or your agency. So, for example, you are a city commissioner and you become a member of the Monroe County Symphony Society, which asks for money every year from the Monroe County Commission. And so you're a board member of this symphony society, and the society is asking for money from the county commission. Well, the first question that has to be answered is, do you have a contractual or employment relationship with the Monroe County Symphony? If you do not, then the statute is not triggered. Well, we know you're not employed, so we can take that one off the table. Do you have a contractual relationship? Maybe, maybe not. Oftentimes, if you belong to an organization, you pay your $10 and you get their newsletter, and guess what? That's a contractual relationship. So you may have a contractual relationship, but sometimes you don't. And if you don't, and you're on the symphony board, and the symphony comes and asks the county commission for money, you're okay, as long as you're not a member, as long as you don't have a contractual relationship. Now, I would advocate that you do not, that you are not the person who, you know, comes and asks the county commission for money, because you don't want to get in the position of people accusing you of misusing your position to accomplish this for these entities that you like. But yes, you would have the threshold question is there a contractual or employment relationship?
And paying a fee to be on a member is a contractual relationship?
Paying a fee to be a member is a contractual relationship. We had that actually come up, and it was much more significant than a symphony kind of example that I just gave. This was a person who wanted to be to run for the legislature, and she was going to be the president of the Association of Realtors or something like that. And of course, they have a lot of legislative issues, and as president, she would be all up in that, as they say. And she said, well, this is a voluntary organization. I don't get paid, which was true. She did not get paid. So I didn't have any contractual relationship. As it turns out, the Association of Realtors does have a contractual relationship with all of its members to the point that they're entitled to certain kinds of arbitration or things of that nature if there are fee disputes. And so there was a contractual relationship notwithstanding the lack of actual compensation. So it's always important to look, see, just like another example of contractual relationships are services performed under license. If I provide pro bono legal services to a citizen, God help them, then I have a contractual relationship with them even if they don't pay me because I'm providing services under my license. So the same would be true for an accountant maybe or an architect or a thing of that nature. So you can have a contractual relationship without compensation, but the more common case is that, you know, you're getting paid to do something. All right, I can see that I need to skip voting conflicts. How bad will that hurt anyone's feelings? Because I would really like to say a couple things about blind trusts. Say what? Well, fine. Steal my thunder. Look, that's what the big red X is for. There are no more blind trusts. Only 3 people in the entire state took advantage of it anyway. I just want to say this about blind trusts. It's true. There were only 3.
The other two.
There were only 3. One was Rick Scott, Nikki Freed, and I can't remember the other person's name. He was like the city manager in Jacksonville or something like that. But we've only had 3 blind trusts. But now it won't matter. But there's a serious misconception out there about blind trusts, and that is that blind trusts enable people to hide assets. To whatever extent that's true, it's the same with any trust, blind or not blind. We had the trust question over there. If you have a business, for example, if I have a business, I report that business as my asset. It's Verlindia Doss Incorporated, and it's worth $500,000. I report that. What don't I report? How many cars it owns, what stock it owns, what other businesses it owns. So I can hide my assets that way. If I have a trust, if I create a trust and I have a trustee for it and I'm the beneficiary of a trust, I report that trust as an asset. I don't report all the stuff that's in that trust. So the blind trust was no different than that. What the blind trust was designed to accomplish was, if the person does not know what they have, then they deserve some protection from the application of the conflict and voting conflict law. So they can't get hammered with a voting conflict because they voted for something that would benefit their business if they didn't know they owned that business. That's the misconception about the blind trust. But it's all over now. It's gone. And the last thing I did want to talk to you about is post-office holding or employment, because I have a funny rhyme and I want to get a laugh. So, all right, for you local people, it used to be only elected local officers, okay? But now that law I talked about before that was passed in 2018, but it becomes effective July 1, 19, now it drags in appointed school superintendents. So they cannot appear before their former government body or agency as well. So we got a question about, we had a person that wanted to appear before their board within 2 years, their county commission or city commission, I can't remember which it is, and we said, no, you can't do that. So then the next question was, well, what if they're, individual out there, like I see them in Publix, can I lobby them then within 2 years? And we said, no, you can't do that. So then we got another opinion request. This is not all the same person. We got another opinion request that said, okay, well, so I know I can't appear before the county commission, but can I appear before this other board over here that my county commissioner sits on? And we said no. And so I say, you cannot represent in a car. You cannot represent in a bar. You cannot represent when they're by themselves. You cannot represent when they're with their elves. So I call that the Dr. Seuss opinion, and it's just to illustrate that it doesn't matter what the capacity of the city or county official is. For that 2-year period after you've left office, you cannot represent clients for compensation before them. And Amendment 12, coming back, what goes around comes around, as of December 31st, 2020, there will be a 6-year ban on representing before your governing body or agency. This is a little bit, the language is a little bit different from the statutory language because the statute says government body or agency, and then it defines government body or agency for county commissioners, for example, to include their chief administrative officer and their immediate support staff. The language of the constitutional amendment does not include that. It just says your governing body or agency. So with that, I will say thank you very much for having me. Whoops. This is our website. This is our phone number. Please call us. I won't be there, but people will be happy to help you. And there's one last question.
Yeah, well, look.
Or maybe not one last.
So you're going to leave, right?
I have to leave.
Okay, and I get an ethics complaint. Can I hire Berlindia Das Consulting?
Well, actually, you can't, but that's because there won't be any Verlindia Das Consulting. But if there were, you could. I cannot, then that's a great question. The question is, I leave my agency, the Ethics Commission, somebody gets a complaint filed against them, can they hire me? And they could, but I could not appear before the commission, meaning I could not represent you before the commission. I could not appear before them. I could not file papers. I could not do anything before the commission. But I could consult with you and give you advice. And if I had employees, if I had staff, those staff members could appear before the commission. The prohibition is personal to the official, not to other people that he works with. And there was another hand.
It was mine, but you answered it.
Okay.
So does the representation involve a cash flow, or could be, I don't run again, and I want to go before my court and tell them what they're doing wrong on behalf of customers with whom I have no relationship other than the fact they're getting badly treated?
Good question again. Is there a compensation element? And the answer is yes.
So
It's
that's in compensation, I can go back to.
without compensation, yes. You can represent people before your board without compensation.
Okay, good, thank you.
Yes, yes.
And you can also speak your own mind.
And you can also speak your own mind.
On your own
Yes,
behalf.
Yes, absolutely. Yes, once you're just out there in citizen land, I guess it's Katie bar the door. Woo! Thank you all so much. I really enjoyed this.
Maybe kind of like palatable, so, Beth, please.
Thank you. Thank you very much. It's a pleasure to be here, continuing with the Open Government Ethics Seminar that has been put on for all of you. I'm not really sure where we are time-wise, so if somebody could just tell me 10 minutes before the time limit for the statutory requirement, whenever that is, so I know to wind up. Everyone will be elated, I'm sure, at that point. And I'll also be around for a while to answer questions, and people are free to ask questions as I go along. Sometimes the organizers of events ask me to please save all questions till the end, and I'll think to myself, yeah, that's fine with me. But people in the audience, I find, are going to ask questions, and there's no point in stopping them. Please try to avoid, though, sometimes I do hear people asking what appear to be very precise questions about somebody else's conduct. This is not a helpful forum within which to discuss those types of issues. Hopefully, I'll give you enough information here today so you can go on and feel fully compliant with Florida's Sunshine and Public Records Law. Both of these laws enacted in 1967. The Sunshine Law, Florida's open meetings law, for which we are nationally renowned, adopted in that year to great fanfare as a result of a 20-year effort by a legislator from the Gainesville, Alachua County area who, in one of these stories that sounds almost scripted, but apparently is based on fact, Senator Emory Red Cross, as a young man, accompanied his father, who was a lawyer in the Gainesville area, to various proceedings, including going before local governing bodies like the City Commission and the County Commission. And Senator Cross noticed that all of the decisions seemed to have been made ahead of time. In other words, maybe some people might like to see that today, meetings of public bodies were very short because the City Commission or the County Commission or even the cabinet members in Tallahassee usually would have breakfast meetings, be closed to the public, where everything would be hashed out, and then they would go down to the public meeting room and have a very short meeting in public because all the decisions had already been made behind closed doors. So Senator Cross, as a young man and as a lawyer starting out, thought this was fundamentally anti-democratic. And he also noticed that certain people seemed to do very well during these local proceedings when they brought cases, and others did not. And there was no way to hold anyone accountable for what happened or to learn what went into the actual decisions because they were all closed. So for 20 years, he fought in the Florida legislature for the enactment of an open meetings law that would provide broader access to members of the public than had existed for many years in Florida. The efforts that he made were resoundingly defeated in the legislature, which was at that time controlled by people from North Florida. The saying went that back in those days, pine trees had more votes than people from Miami or the Keys or Orlando, because the way the legislative districts were set up, these more sparsely populated counties in North Florida carried all more weight. And finally, this system, and of course, one fundamental precept about open meetings laws is that those in power are never as supportive of them, in my experience, as those that are seeking power. So in this case, the legislators from South and Central Florida were most advocating for open government, but because they did not have a voice that was strong enough to reflect their numbers in the legislature, these efforts were doomed. It's interesting, though, that the architect of the Sunshine Law himself came from the Alachua County, almost North Florida, not kind of close, not Central Florida, really that whole Gainesville area, just kind of in its own world there. But the federal courts finally reapportioned the legislature in the 1960s. They gave up on the efforts of the Florida legislature to do it itself, and as a result, the reform-minded legislators like Sandy D'Alembert, who just passed away, and others from the area of Florida, from here, were finally elected in numbers to make a difference. And in that first reapportioned legislature, the Sunshine Law passed, as envisioned by Senator Cross, requiring all meetings at which official acts are taken are hereby declared to be public meetings. The second component, though, of our Sunshine Law is seen not in the actual language of the statute itself, which today, with this talk of strict construction of statutes, would be probably something of a point of discussion. When the courts first began hearing cases involving challenges to actions by local governments as violating the Sunshine Law, the local governments, the first cases involved the city of Miami Beach, the city of Doral in South Florida, that had public meetings of the entire city commission. But the question was, what about those meetings that are less than a quorum? What about meetings where no official action, as that term is ordinarily understood, were taken? What about those? The news media and citizen activists asserted that the Sunshine Law should be broadly read, and the Florida Supreme Court, at that time, the Chief Justice, James Adkins, also mysteriously from the Alachua County area, another person, a strong proponent of open government, wrote the early court opinions interpreting what is a meeting at which official action is taken. And in his analysis in these early cases, it was our open meetings law applies to any gathering of 2 or more members of the same board to discuss some matter which will foreseeably come before that board for action. So this has 2 components to our Sunshine Law more than any other state. First, any 2 members of a board are subject to the Sunshine Law, not just a quorum, not just the full board, not even a committee, any 2 members. And what kinds of actions or discussions can they have that are subject to the open meetings law? Some matter which will foreseeably come before that board for action. That is such a broad standard that it's far broader than just those matters that are on an agenda scheduled for a vote. And this is the most common misconception that I see about the scope of the Sunshine Law. It's not just those things that the board has decided or by law are scheduled for a vote. It includes informal discussions. It includes workshops. It includes things like who's going to be elected the chairman of the board. All of these issues are subject to the Sunshine Law. So at some point, I remember several years ago, talking to a group of newly elected county commissioners at a training session. The Association of County Commissioners, the League of Cities, and the School Boards Associations all do excellent training on Florida's open meetings and public records law. But I was substituting, I think, for one of the county attorneys at this, and a newly elected county commissioner said, well, this means there are no private discussions ever about public business affecting our board. There's no executive session. There's nothing. Everything has to be open. And I thought, yes, correct. In fact, I thought maybe I can just sit down, because that's the heart of the Sunshine Law. If you see 2 board members and they're discussing board business and they're not doing it at an open noticed meeting, then they're in violation of the Sunshine Law unless the legislature has passed an exemption that authorizes them to meet behind closed doors. And there are very few of those. Our state is different than other states where boards have more discretion to decide, well, this is a very private matter. This is dealing with an employment situation, for example. We don't want to have to discuss all of this in open session. And in Florida, yes, all of this has to be discussed in open session. There's no asking people to leave. Only the legislature can create those statutory exemptions. So The early decision by Justice Adkins interpreting our Sunshine Law remains in effect today. So I feel that this becomes relevant with the large numbers of people that we have who come here from other states, and they will say, if they're elected to one of your boards or appointed to one of your boards, maybe some of you have seen this. They'll say, well, of course we can have a closed session involving just 2 people. That's what we do in Ohio. Well, who cares should be the response there. They're not in Ohio anymore, and probably glad, even when it's raining in the Keys. It's better than Ohio in the winter. So they have to give up some as public officials to come live in the Sunshine State, and one thing is the Sunshine Law. As a general matter, my experience is that if there is somebody other than Bob Schillinger, for example, telling you something doesn't need to comply with the Sunshine Law, if he tells you that, it's because there's a statutory exemption that he has followed to the letter of the law. If somebody who's a random member of the public tells you that, I say don't listen to them. Most of the difficulty that public boards get into with the Sunshine Law involves somebody who is a so-called expert from with an interest before the county commission or wanting to help them, sort of like the kind of point that Verlindia is making. There are a lot of people out there in the public who, for their own reasons, want to help board members or give them things, and sometimes what they want to do is come up with ways they can avoid the Sunshine Law. None of those ways work. The Sunshine Law has been in existence for almost 50 years. They've all been tried. As technology changes, more and more so-called opportunities to try to violate the Sunshine Law come up. They all failed. For example, board members cannot engage. This was the original situation that used to happen with the Sunshine Law. A group of board members would go on their own into a private room and have a discussion about public business and hope that nobody would find out about the secret meeting. This is another thing I've learned. Somebody always finds out. Sometimes they'll find out when one of the board members will forget that it violates the Sunshine Law to do this, and they'll admit it at the public meeting. Well, John, why are you voting that way? Remember, we discussed this at the private breakfast. They forget about it so easily. So, no private discussions face to face. But what about, believe it or not, these were circumstances that arose when the Sunshine Law was first passed. What about private telephone calls? Surely it can't violate the Sunshine Law for one board member to telephone another. Yes, it does, unless they have the authority to hold public telephone calls with the public invited every step of the way, as I believe has happened in Monroe County with, again, the county attorney's office shepherdizing how to conduct all of those public telephone call meetings. It violates the Sunshine Law for 2 commissioners, 2 board members to talk to each other about board business over the telephone. And that's another one where people, I don't think they start off intending to violate the Sunshine Law. I think what happens is they call each other to say, are you going to the Rotary meeting on Wednesday? Does it violate the Sunshine Law for 2 board members to talk about a private event? No. I mean, if it's not related to board business, board members can talk to each other. The Sunshine Law isn't a law that prohibits board members from talking to each other. They don't have to walk in separately wherever they go. Although I have been on boards, now you're probably thinking, oh, great, I'd love to be on a board that she is on, but I have been appointed to advisory boards, And then it is true that everyone moves away from me. I have no friends. They all sit away. They're all worried that somehow they'll do something wrong, when in reality, one board member talking to me, probably not that good an idea. But keeping in mind that board members cannot telephone one another about board business, so they start off, though, with the Rotary meeting. That's not a violation of the Sunshine Law, but then somehow the conversation drifts to an informal discussion of some matter coming before the City Commission, and all of a sudden they're in violation of the Sunshine Law. And the way that the Sunshine Law case comes about is one of them forgets all about it again and mentions it at the public meeting. So the best thing that I would recommend, of course, is if I was on a board and I got a telephone call from another board member, I'd be reluctant to take it. One never knows, and you're really putting your fate in the hands of the other board members. Now, there have been, because the Sunshine Law does only apply to discussions of public business affecting the board that the people are on, it does not prohibit private conversations. We do have an Attorney General's opinion dealing with a situation where a husband and wife are serving on the same board. So it's not illegal for them to talk to each other, although you sort of have to wonder the dynamics around the dinner table in that situation with them both being on the same board. But they cannot discuss public business. So the Sunshine Law trumps essentially whatever other relationship you might have with another person. If you're business colleagues and you're both on the same board, the Sunshine Law doesn't allow you to switch hats and say, now I am talking to you in your capacity as a board member. I'm going to do that at the public meeting, but I want to talk to you about an issue coming before the board that's the same one, but this time we're discussing it in our business capacity. No, the Sunshine Law is all pervasive. Once you're in and a member of a board, it will affect all of those conversations relating to board business, even if you might have a secondary reason to discuss those things. So telephoning, a violation of the Sunshine Law. Most of the early Sunshine Law prosecutions involved two board members telephoning one another. Then emailing. Once email was developed, that became the basis for most of the modern Sunshine Law actions. And I'm sure it's occurred to you why. With a telephone conversation, suppose two board members, even if their bills reflect they talk to one another, maybe one of them has amnesia. What did you talk about? Oh, I don't remember. Probably the Rotary Club or something. It sure wasn't public business. So that unless one of them admits that they violated the Sunshine Law, it's very difficult to prove with a spoken conversation. Contrast that with email. The emails usually start out maybe on the office email, we really should discuss this county problem affecting our board on our private email servers. So there you go. There you have not only evidence that can lead to finding more about those conversations conducted via email, which are also required to be kept under the Public Records Law, but the actual content is right there. No more amnesia. It's right, and secondly, the intent component, which is a factor in a criminal prosecution, is also right there. I know we shouldn't do this, but we really need to. And then sometimes it'll be even better because someone will respond via email Doesn't this violate the Sunshine Law? Go back to the very first principle, unless your lawyer is telling you it's okay. That if someone says, no, it doesn't violate the Sunshine Law, all of those conversations documented. So no Sunshine Law conversations via text either. And then I just had to add, or any other type of communication. What about Facebook postings? One way our opinions will say, I might as well mention this out right now, a one-way written communication, whether Facebook or email or text by a member of a board to another board member about board business, does not, under our opinions, constitute a violation, provided that that one-way communication is kept as a public record and there is no response. Now, having said this, this is like one of these things where you've got a law, and if you jump through this hoop and nothing else happens to you, you won't be in violation. But can't you see the problem right away with that many public officials do? If you do those one-way transmittals, say a post on Facebook, I'm going to vote to fire the superintendent. Anybody in? Well, that's like sort of a solicitation for a vote. Well, under our opinions, and see, we sit in the ivory tower in Tallahassee. We're not down here trying to run the government like you are in your county. So that's why we can say, that's my example. What about firing the superintendent? Are you in? One school board member says that. Well, technically, and remember, I'm not talking about the wisdom of this statement. It's kept as a public record, and if there's no response, then there's no violation of the Sunshine Law. But suppose there is. Somebody posts and says, I think you're being mean to the superintendent. He's doing the best he can. They're both in violation of the Sunshine Law. So for that reason, the caution I would give is that if you send one-way transmittals, particularly on Facebook, where everyone can see them, that it's a dangerous business to do. I would not do it, because you are throwing your fate in with somebody else to not respond. And even if you put on this posting, some of you may have noticed something like this in other, I have seen it, where they'll say, I think we should fire the city manager. Don't respond. That would be a violation of the Sunshine Law. Well, suppose all this person sees is fire the city manager. They don't see the caveat where you're saying, please don't respond, and they respond anyway. This happens all the time with emails. They don't scroll all the way down to the bottom. So unless you were to encircle your entire email with do not respond, even that doesn't ensure that somebody won't. So increasingly, and this is something that public officials may have already seen, that this is very hard for members of the public to accept. Say there's a string of conversations on Facebook, and one member of the public raises one of these issues, and a board member tries to respond. They won't understand why many times the board members will cut off the discussion. They don't want to have a potential Sunshine Law issue. Sometimes I've had a citizen call me the other day and say they got a private message, and I'm thinking, well, it's really not a private message from the commissioner. It has to be kept as a public record. But I knew what he was saying. The citizen was concerned because the county official had private messaged him, I can't respond to all of these communications from other board members, and that you're trying to have this discussion as a citizen with these other board members. I just can't participate. Once one posts, I really can't. And the citizen is not understanding this. And I thought, well, what the county commissioner in that case, nothing here that I'm saying today, unlike for Lindia's Monroe County examples, I have none this time. This time. All of mine are other areas of the state. But in this case, I think the county commissioner is being kind, I think, to the citizen in explaining that they are not trying to cut off debate. They are concerned about the Sunshine Law, showing once again that even that members of the public sometimes can be amazed at the far reach of the Sunshine Law, and that sometimes public officials' reluctance to use social media to engage in debates, that's based on concerns about the Sunshine Law, and those are legitimate concerns. Because if there's a prosecution, for example, with involving the Sunshine Law, these citizens are not involved. They are not the ones who are required to comply with the Sunshine Law. So many times, members of the public can see that there's no violation to them, but it's the public officials that bear the brunt. So caution with Facebook and blogs. Moving ahead to the next danger area with regard to the Sunshine Law, and this relates again to some of the Facebook conversations. This is called use of a liaison. It sounds very sinister, doesn't it? Use of a liaison. This is one of the first principles to develop in the case law after the Supreme Court announced the broad reach of the Sunshine Law to apply to any gathering of 2 or more members of the board to discuss any matter on which foreseeable action could be taken. When that standard was announced in the early 1970s, boards had a choice. They could just say, well, this is the way it is. I guess now the old way, no more breakfast at the Florida Inn Hotel like the Florida cabinet used to do before the governor and cabinet meetings. No more going down to Denny's and hashing everything out. No more private meetings with people involved with business before the city. Now everything has to be in public because that's the law. They could have done that, but instead people, and perhaps this is understandable, just could not even envision doing business entirely in the sunshine. And they kept trying to think of ways to get around it. And one was this use of a liaison. Remember, I droned on about how the Sunshine Law applies to any gathering of 2 or more people. Well, suppose there's only 1. Does the Sunshine Law apply in that situation? And usually the answer is no. 1 member of a board cannot violate the Sunshine Law. So, for example, if a member of the school board goes to a meeting with city staff, not a violation of the Sunshine Law because there's only 1 member there. So boards thought, well, one way to maybe, and they didn't see this so much as a circumvention of the law, but a way to more efficiently operate the government. When I look at these cases, none of these cases involve circumstances where people tried to avoid the Sunshine Law so they could give themselves a big raise or benefit somebody that they were close to or take action on a controversial proposal without the public knowing about it. They all involved circumstances. Most of these early cases involved school boards who have, in many circumstances, it's not always true, but in most communities in Florida, and maybe the same in other areas of the state, issues that people care about the most, I would have to say, more of those issues to more people will involve school boards. Where their children go to school, what the school calendar is, How are they handling security issues? These are of vital importance to people within a community. So what happens is, if an issue comes up on the agenda, like changing school boundaries, redistricting, you buy a home in one neighborhood, and all of a sudden your kids aren't in that school district anymore. The other issue that comes up is closing a school. Many times, I don't need to tell you, the schools are the heart of a community, and if a school closes, that's an extraordinarily difficult circumstance for a community. So in these cases, the hearings and debates go on and on and on and on. And how do you refine, as you would maybe in a private setting, what are your options? All the things that a private organization could put on a whiteboard or something, or a dry erase board, something like that, and try to figure out what the options are. Everything that a public board does in Florida is all in the sunshine. So eventually the decisions are made, but it takes a long time. So using a liaison was an idea that a school superintendent came up with when the school board had already debated for hours whether or not to close the school. The school superintendent went to each school board member, one after the other, and basically said, "What are you thinking?" And even though usually a liaison case then that's in violation of the Sunshine Law would proceed then in one of two different ways. One way is the superintendent would relay on the different views of the school board members to each other. So school board member A learns from the superintendent how school board member B feels about the issue. Neither one of them have announced it in public, but they're telling the superintendent one-on-one, who then passes this information along. The courts say that violates the Sunshine Law. They're sympathetic to why board members are doing it, but it violates the law. The second way that can be, usually you see that principle being done, and there have been several cases involving someone passing on the views of one board member to another. It almost always occurs in cases where the board is considering whether or not to terminate the employment of its chief executive officer. A city council has determined that it needs to go in a new direction. There are all these euphemisms for that as vis-a-vis the city manager. As in one case, at the public meeting, the city manager, one of the city commissioners said, "This is awful. We don't want to have to go through this in public like we did the last time. Isn't there some other way?" Default back to the answer, there is no other way. It has to be done in public. But in this case, and it's very interesting how this case developed. One person was a strong advocate on the city commission with terminating the employment of the city manager. They had several, and this was yet another example of this one commissioner and the city manager in particular not getting along. The person who wanted to get rid of the city manager enlists the aid of a city official, not a member of the city commission, to hold rapid-fire meetings all weekend long to try to see whether or not some sort of agreement could be worked out with the city manager to have this person terminated. One thing that's very interesting about this is all of the city commissioners participated in these discussions with one exception. A city commissioner said, "I don't feel this is right. I think it violates the Sunshine Law." that person trusted their instincts and was not a defendant in the eventual lawsuit. And to me, that's always a lesson that is worth repeating. And that is, if I am on a board and something just doesn't seem right to me, it could be a violation of the Sunshine Law, don't participate. That's always something that your board attorney would want to hear about. There's been several cases where boards were charged with violating the Sunshine Law by the state attorney's office, and the city attorney knew nothing about it. Instead, someone else orchestrated all of the meetings, and the city officials went along with it. It must be something psychological that people sometimes want to, if someone tells you something you want to hear, that's the only explanation I can give, then they want to believe it's legal. And with the Sunshine Law, that's not the case. If you have received advice and counsel from your the attorney for your board, who's showing you a statutory exemption, or telling you, remember, even though she said all sorts of scary things about the Sunshine Law, it doesn't apply to a private conversation between two board members. Your board attorney is the one that can tell you and provide legal advice in this kind of situation. So here, in this case, the courts reiterate again, as they have done many times, that there's nothing wrong with an individual board member talking with a member of the public or with city staff about an issue. Vice versa. City staff can inform the board members. That's what they should do. A member of the public under the Sunshine Law, there may be other factors that come up with regard to communications with an individual member of the public, but the Sunshine Law is talking about those circumstances where you have that member of the public being used as a liaison by the board members to pass along information, or a city staffer or county staffer polls the members of the board, as in this case involving the termination. The court's saying that's different than your usual fact-finding or briefing by staff on a one-to-one basis. When you take action as a result of these one-to-one meetings, then that's where the Sunshine Law violations occur. There was another case involving a board attorney who briefed all of the members of a board in the same circumstance about an issue that was going on, and one day later the board members all vote to terminate the employment of that person. The state attorney in that jurisdiction filed charges. Now, the court did dismiss them. There, the court finding that these were staff briefings, not a violation of the Sunshine Law, but still showing how the broad reach of the Sunshine Law, just because there's one person involved in the situation, does not take it outside of the scope of the Sunshine Law in all circumstances. These liaison cases, you're seeing more and more of those. I'll close with one more example because I think you might find it useful. Sometimes one never knows, even if you're not on a board, whether you might offer your services as a liaison. And this case in the Central Florida area involved a lobbyist who saw that a board that he did business with was having difficulty with their executive director. You can see sort of a pattern here. They're very uncomfortable about discussing this in public, but yet, as you know, that's the only option. Everything has to be discussed in public. At that time, the lobbyist decides to offer his services to act as a negotiator, liaison, I don't think he used those words, to try to craft some sort of agreement that would allow the executive director to move on. So inevitably, since all these discussions were conducted via email, it was clear that the board members violated the Sunshine Law. The emails documented that the liaison was essentially orchestrating the departure of the director. So a complaint was filed with the state attorney, who filed charges against the board members. There was no dispute that they'd violated the Sunshine Law, so they pled no contest and paid a civil penalty for an unintentional violation. But the state attorney was concerned about the fact that these board members essentially got into difficulty because of what the liaison had done. They didn't go to him. He came to them offering essentially liaison services. So the state attorney went after the liaison and prosecuted him for attempted Sunshine Law violation and aiding and abetting. Well, this is the ultimate irony. The judge dismisses the charges against the liaison because the liaison is not a board member. So isn't that ironic? The board members really, if you look at that situation, they should not have engaged in these, used the liaison in this way. But they weren't the ones that came up with the idea. But they are the ones that are responsible, like so many other things. It's the board members that are held to the standard of knowing what the Sunshine Law does and does not require them to do. And this liaison was simply a member of the public and was not held to any standard whatsoever. So with that alarming thought, let's move on to what the requirements of the Sunshine Law are. This is relevant, I think, primarily when you have questions, as we'll be discussing in the next slide, about whether or not a particular group is or is not subject to the Sunshine Law. A lot of agony is spent over these types of issues, particularly with advisory boards. And that's a good time to point out that that when you look at the requirements of the Sunshine Law, they are not that onerous. They require that the meetings be open to the public, keeping in mind that a meeting is any gathering of 2 or more members to discuss any matter on which foreseeable action can be taken. So open meetings, reasonable notice. The Sunshine Law does not define that term. There are other statutes. For example, school boards have specific notice requirements for their meetings, and they use those. County commissions have some notice requirements. That's your reasonable notice if a statute provides those. For special districts, Chapter 187 has notice requirements. So meetings must be noticed, keeping in mind that even though the statute says reasonable notice, the cases recognize that sometimes boards have to act in an emergency, and probably very few people know that as well as people in the Keys, where you do have weather-related emergencies and limited opportunities to evacuate. So sometimes people have to act quickly. The courts say a board can provide emergency notice when an emergency occurs. And there have been several examples of that. In Northwest Florida, I remember that I was impressed, as I often am, with how local government responds in these situations. The town of Mexico Beach, you may have read, was virtually leveled by Hurricane Michael, but within a couple of days, the town council is getting together at the one semi-standing building to try to talk over ways to get aid to the citizens in that community. And one citizen called and raised questions about this. Now, see, that's where I have to remember that don't say what you think. Because I'm thinking, these people are trying to help you. I mean, they are, I'm saying, but then I figure this citizens, if they're living in that area, they're going through a hard time, and maybe they just want to protect their city council. But that's an example of where the city council provides the best notice that it can of meetings being held to provide aid and assistance. That might mean something like just putting whatever sign you can out there, just trying to the extent you can provide notice to people, doing the best you can. The better or the more need there is for emergency action, the easier it is to justify emergency notice. A school board that gave an hour-and-a-half notice of a meeting to hire a lobbyist to lobby for them in Tallahassee, was that an emergency? Could they have provided more notice than an hour-and-a-half? The court answering yes to both of those questions, but your weather-related issues that sometime, or other emergencies that come up, that can be reasonable notice there. When people ask me about that, I'll always say, well, if you had to explain a judge, what was it that you needed to do and the kind of notice that you provided, would you feel comfortable explaining that someone would understand? And in your true emergencies, that's not a problem. The other requirement of the Sunshine Law that sometimes people overlook is that you have to prepare minutes on all Sunshine Law meetings, and that includes workshops. And then those minutes are subject to access under the Public Records Law. If the clerk has prepared draft minutes, they're still subject to access under the Public Records Law, even if they're not yet the official minutes. In that situation, you'd label draft, draft, draft. I mean, a lot of times I can understand the reluctance of government agencies to provide minutes that have not been voted and approved. But the solution there is to put on, in my judgment, on the draft minutes something that says draft minutes, not yet approved. So that way you can comply with the Public Records Law as well and ensure that the minutes that are approved truly reflect what happened by that governing body. I alluded to this earlier. Many boards like to create advisory boards. We have an Attorney General's opinion. By the way, I don't write the Attorney General's opinions. They come out of our opinion staff. I say that because I guess several reasons. If you read one you don't like about open meetings, I didn't write it. Nope, not me. If I wrote one you did like, it's the same thing. It's not me. It's our opinion staff, and I consult with them as they're drafting those, and of course ultimately they go out of the Attorney General's office either as a formal opinion signed by Attorney General Ashley Moody, or they are an informal opinion signed by one of our opinions attorneys. In any event, unlike the binding opinions that come, the formal opinions that come from the Ethics Commission, our opinions in any area are only advisory, and we only issue them to public officials on questions relating to their official duties. And for collegial boards, it has to be a majority of the board or the board's attorney asking. This reduces the number of times we'd have people who are on the losing side of a proposition asking for an Attorney General's opinion. We require them to come from the majority. But one of the questions that we did get, we've gotten this a lot, involves a county commission chair who wanted to create an advisory committee composed of citizens, but yet not have the Sunshine Law apply to those citizens. I get a lot of questions about this from people who want to create these kinds of committees. And what they're looking at is they're trying to articulate that this particular advisory committee is acting only in a fact-finding capacity. And this is another example of how some of these opinions that say that certain types of behaviors are legal, i.e., the one-way written transmittal, if kept as a public record from one board member to another, is not a violation of the Sunshine Law as long as there's no response. As you recall, I caution against doing that. Don't do those because your fate, Sunshine Law-wise, is in the hands of someone else who may respond. Similarly, the case law says that there's no fact-finding exception for boards making the ultimate decision, like a school board. So school board members can't talk amongst each other and say, well, we're only fact-finding, so therefore I can talk to another school board member. The courts say, no, if you are a member of a board making the ultimate decision, no fact-finding exception. The legislature has tried for 2 years to create an exception from the Sunshine Law that would allow fact-finding discussions under limited circumstances, like if they were tape recorded. And it's interesting to me that even though there's been no opposition to this, the First Amendment Foundation, an open government advocacy group, has not argued that there's any problem with this, but yet it does not pass. And I'm not certain as to why. I think some of it could be that the legislature just, which as you know, not subject to the Sunshine Law, doesn't really understand the difference between that would necessitate this, or they could be afraid their constituents won't like it. I think it's a fundamental principle, at least from my experience, that people that complain about the restrictions that the Sunshine Law places on their activities are almost always government officials. The public never complains about this. The public never says, well, I wish, unless it involves them, unless they, as in my experience, a member of the public would like to talk himself or herself with 2 commissioners, but they don't want anybody else to do that, is my experience. Government officials only want the ability to have more flexibility with regard to the Sunshine Law. In my experience, the general public disagrees with that. So maybe for that reason, the legislature will not pass a fact-finding exception. But it does come into play with creation of an advisory committee. One thing that the courts have made plain is early on that advisory committees, even though they only make recommendations, and by advisory committees, I mean committees composed of people who are not members of the board, like citizens, or they could be staff members, to make a recommendation. Early on, the city council in Palm Beach created such a citizen committee in the 1970s to make a recommendation to them about whether there should be changes in the zoning laws. The city council did not make them comply with the Sunshine Law, and they did not. They held essentially private meetings with various interest groups throughout the community. And as a result of their meetings, they presented a revised zoning code to the town of Palm Beach, which then accepted it at an open public meeting. Members of the media sued, alleging that the committee, the advisory committee, violated the Sunshine Law. The city responded, there are not 2 or more members of an elected or appointed board present. This is a citizen advisory committee. The Sunshine Law does not apply to them. And again, in an opinion written by Justice Adkins, I believe, he says essentially, yes, it does. The Sunshine Law does apply to advisory committees composed of citizens in this case, and in a later case composed of staff, because they are part of the decision-making process, even though they don't make the final decision. And his rationale was that if you allowed the closed meetings to occur, you would never hear of all the options that were considered and rejected. If you just have a final version, in this case of a zoning code, you would never know, the public would never be able to find out why a particular area was designated as commercial. Were there people who thought it should be residential? You would never know any of this. And his argument was, in reality, that's as important as the final vote, is to know what prompted the recommendation of the committee. So advisory committees subject to the Sunshine Law, but the court did say in later cases that if all a committee does is provide information and facts, like in this zoning committee of from the town of Palm Beach, the court's suggesting in other cases that if the advisory committee had not really made recommendations, but instead had just put all the options out there. We heard from the downtown merchants, and they said they want more designer clothes over there at stores on Worth Avenue, whatever kinds of, and other historical preservation people, they advocated for greater preservation interests. If all of this had happened, then the public would be able to learn about and see everything that they had done. So this fact-finding exception for advisory committees started to be developed, leading to the question from the county commission chair in, I believe, the South Florida community, further north, asking what he wants to create this advisory committee of citizens and call it fact-finding. First of all, he said, I'm the only one creating it. Can I, as an individual commissioner, create a committee subject to the Sunshine Law? The courts say yes. A committee can be created by the full board or by an individual commissioner advising that commissioner. That was established in a case involving the advisory committee created by the president of the University of Florida. He created a committee that was an advisory committee subject to the Sunshine Law. So yes, an individual chair could create an advisory committee subject to the Sunshine Law. So then he's thinking, well, I don't want these citizens to have to comply with the Sunshine Law. How about if they're just fact-finding? And the opinion points out all the criteria that would have to be met if it's only fact-finding, leading anyone, which is very difficult. In other words, it's very difficult to create a committee that does only fact-finding, because while the committee may intend on the very first day that they meet to do only fact-finding, very few committees can restrict themselves. And the minute they go into the recommendation area, they can cross the line, and you're thinking, well, who would file suit against an advisory committee and accuse them of violating the Sunshine Law? The answer is many people, especially if you don't like the ultimate outcome of what the advisory committee did, or you feel otherwise that you weren't a part of the process, or your views were not heard. So for that reason, the advice I always suggest, if someone is proposing creating an advisory committee, have it meet in the sunshine from the beginning. Their opinions are valuable, and these advisory committees devote a lot of their time away from their families and businesses to do something for their community. So it is not a good compensation to them after all their hard work to have someone file a complaint against them alleging they violated the Sunshine Law, sue them, all of which has happened, alleging they violated the Sunshine Law, and this to me is almost the worst. I think having complaint filed with you just for doing public service for your community. It's hard to imagine anything that I think is harder on a public-minded citizen than that, is as we'll see, if action is taken in violation of the Sunshine Law, it's void ab initio. So a whole year's work can be undone, which has happened before, has to be reheard, redone by either the advisory committee itself or the appointing authority. So you've got people who are public-spirited citizens, names written up in the newspaper as potentially violating the Sunshine Law. You've got all the hard work they have done evaporated. You've got potential court case or a criminal complaint filed. So if someone asks the question, well, is there a way for them to meet and not violate the Sunshine Law? My answer would be probably not. Assume you're subject to it. There is that, for purposes of what's better for these people, in my judgment, it is to advise them that the Sunshine Law applies and give them instruction in what that means. Last year was probably every year there are 1 or 2 cases involving these citizen advisory committees. Last year's example was a school board superintendent, a single individual, again, can appoint a committee subject to the Sunshine Law, appoints a committee composed of school principals, parents, and teachers to help make a recommendation to the superintendent for submittal to the school board on redistricting boundaries. These people are not told that the Sunshine Law applies to them. So what do the parents start doing? Immediately emailing back and forth. This is our strategy. This is what we must do. And of course, once the recommendations are made, the Sunshine Law case follows. So that is always my message. These people who are on these committees, I think, are depending on public officials to advise them about the Sunshine Law, make sure they go to training or have available training to figure out how to comply like you do here. You have many advisory committees. They're busy doing things that make things better for people in the community. They shouldn't have to worry that they're not being given instruction in the Sunshine Law. I mentioned earlier that the Sunshine Law can even apply to a staff committee. That is unusual. Normally, staff can meet amongst themselves and discuss things like staff does a Monday morning staff meeting. For example, we have those in the Attorney General's office. Sometimes they're on Friday, which is not well received, I can tell you, but yet it would never happen here, right? One more reason to live here, right? Sometimes they do that in Tallahassee. So normally those aren't subject to the Sunshine Law. However, if you have a staff committee that is appointed, say, by a purchasing director to create a committee to advise the director and shortlist potential vendors, there can be some Sunshine Law issues there. In fact, the legislature has created an exemption for certain types of purchasing committee proceedings, recognizing that the Sunshine Law can apply. So I only mention this because the general rule is the Sunshine Law does not apply to staff. But occasionally, if you have staff committees, particularly in the area of purchasing and personnel termination, for example, the Sunshine Law can apply. So if you are in a circumstance where you may have those types of committees, I always recommend going to counsel just to make sure that your attorney is familiar with this committee and that all Sunshine Law requirements have been complied with. Keeping in mind that sometimes government attorneys will call me and say, I just learned Whenever you hear anything like that, that's very alarming if you're an attorney. I just learned. Because I know this means it's something that you should have learned a long time ago, it seems to me, but nobody told you. So if you learn a fact like that, it's usually a problem. In this area, the attorney will say, I just learned that in the purchasing department, they have a committee that shortlists all the vendors and makes a recommendation to the purchasing director, who then decides, based on that, where to award the contracts. I'm just giving an example of something that you sometimes hear. And the attorney will have then said, what about the Sunshine Law? And the answer is given. This is another thing that does not make a difference with regard to the Sunshine Law. The answer is, we've always done it this way. Now, wouldn't it be great if you could go in front of a judge and they would say, well, you've been accused of doing X, Y, Z, and you say, not a problem, judge. Always done it that way. So this is something, when you see this phenomenon, just because it's gone on for a long time, doesn't mean you can't go through and review whether or not it's in compliance. Where you're dealing with staff, like I said, the general rule is staff discussions not subject to the Sunshine Law, unlike members of governing boards, which are. But there can be these circumstances based initially on that case involving the University of Florida president found to have created a committee that was part of the hiring process of the dean of the law school. The committee deemed to be subject to the Sunshine Law because it had the power, in part, to screen all the applications and decide who moved forward. Only the legislature can create an exemption from the Sunshine Law, unlike other states where it is much easier for a board to close a meeting. This is my opportunity to just say something that I know you've heard a lot. Virtually all boards operate pursuant to Robert's Rules of Order. That is a nice, whoever Roberts was, and he has rules, and they provide order. They don't supersede the Sunshine Law. They're just rules. The Sunshine Law is in our Constitution and statutes. So to the extent Robert's Rules of Order authorizes executive committees that can meet outside of the Sunshine Law, to the extent people believe it does that, that is not an exemption from the Sunshine Law. Only the legislature creates those. And there are very few. One is your attorney bringing you into a closed attorney-client session to discuss pending litigation or whether or not to settle a case, the actual decisions being done in public session. There's another one for certain collective bargaining discussions with a board's collective bargaining agent, one dealing with security that a lot of boards and their attorneys look at these days to see exactly how that one operates. We do have an AGO, Attorney General's opinion, rather, from July 2018 that explains a little bit about the security exemption from the Sunshine Law enacted after the terrorist attack on the World Trade Center in 2001. An exemption from the Public Records Law does not allow a board to close a meeting. Instead, so in other words, until there was an exemption from a Sunshine Law, school boards had to discuss confidential student records in public. Now there is an exemption from the Sunshine Law for certain kinds of discipline, like an expulsion proceeding. There's some language regarding that. Boards can't ban videotaping, tape recording, or photography as long if it's non-disruptive. I was thinking about taking this slide out because I thought, I've never seen a board do that. I've seen people photograph all the time with their cameras, etc., and run a tape recorder. But then there was a case in one area of Florida where a city council was annoyed that the local newspaper was always taking unflattering photographs of the city commission. In other words, somebody be asleep or on their phone, and these pictures would then show up on the front page of the newspaper, another city commission meeting wasting your tax dollars or something like this. So the mayor gets annoyed at this because it's obviously unfair. The meetings might have gone on for a long time and a person was only asleep for a moment or so. Unlike I was going to think here. This would really set me off by this time. Anyway, so he bans photography without approval by the mayor. And of course, the First Amendment Foundation wrote him a nasty letter threatening to sue him if he didn't lift the ban immediately, which the city attorney did. So I decided I had to keep the slide in there in case there were other unflattering photographs out there. Hopefully not in this group. Sorry. Several years ago, court decisions made it clear that the Sunshine Law provided an opportunity to attend a meeting, but does not require a board to permit public comment. The court's saying the Sunshine Law is attend. Public comment is not in the Sunshine Law. In reality, where you see public comment come up more than anywhere else, it's as a First Amendment kind of issue, right, to address grievances. But the legislature was annoyed at the 1.1% of boards that did not allow public comment. So they rush into action about 5 years ago to enact 286.0114. Notice this is not a part of the Sunshine Law. When I talked about criminal penalties, civil penalties, that's the Sunshine Law. This statute requires boards to provide an opportunity to be heard before they take action. The opportunity to be heard does not have to be at the same meeting where they take action, although most boards do that routinely at every meeting, just within at least reasonable proximity. Boards can maintain orderly conduct, proper decorum. There's rule authority to adopt reasonable time limits on public participation. Otherwise, I think the legislature concerned, and I've seen this phenomenon before, where someone might say, I should be allowed to discuss my point of view for an hour and a half, and you should limit everybody else. It's interesting that the governor and cabinet, on some of the issues that came before them when I worked as a cabinet aide, I was always intrigued at how courteous the governor and members of the public were, or members of the cabinet were, to the members of the public that traveled, some of them maybe from here in Monroe County, all the way to Tallahassee to be heard primarily on those land planning and environmental issues of particular concern here. And they had time limits, and Governor Bush in particular had a red light that he would have one of his staff operate. I see some of you here in the Keys thinking, I wonder if we had this red light, what would happen? I'm thinking somebody might just get that red light, but do you really? Well, this was a great big red light that would flash, just sort of like when you're in court. And I remember he was so deferential of the people that would come up there. But when that red light would start flashing, it'd be, now it's time to wrap it up, you know. And and I remember, though, one time when Governor Christ was governor, that there was a lady that would not wrap it up. And so she just kept going. And so he finally said, you know, Mrs. So-and-so, you have a remarkable hat. And she was it was remarkable. It kind of had all these vegetables on it and everything. She was making a point with her hat. And so that stunned her, I think, so much that she was able to just finish her presentation. But the point is that these time limits, essentially what happens with these types of cases is they really end up being a First Amendment issue in my judgment, and you won't see that many examples of this statute. But it does show how often the issues that people are concerned about, when the legislature heard about how people felt that had an issue that was of critical importance to them, a new industry coming to the area, for example, and their city and county commission would not hear from them, people in the legislative committees, just tears running down their face. And at that point, that's when the legislature took action, I think, to help make sure that people had that opportunity to speak. If there is a violation of the Sunshine Law, a civil action can be filed against the board, and if the court feels that the board violated the Sunshine Law, all action taken in violation of the Sunshine Law is invalidated. Now, a board can have a cure meeting, and you'll see that sometimes if a board is inadvertently, this does happen, failed to notice their meeting, the person that was assigned to do that failed to do that, then they can go back and have a cure meeting where they take action and over again in independent, full, open session, and that can cure the violation, or that can cure the invalid action, although the violation is still there. There can be criminal penalties for a willful violation. That's a second-degree misdemeanor within the jurisdiction of the Office of the State Attorney, which is why many of the state attorneys, like State Attorney Ward, have these sessions. Some might say, well, you have to listen for 2 hours, but that's better than having a criminal complaint. And a lot of the discussions that I do are brought about by people wanting to make sure that there's no lack of knowledge that the Sunshine Law is broad and applies to all the governmental boards. A non-intentional violation can be prosecuted as a non-criminal infraction, sort of like a traffic ticket. And in all cases where sunshine actions are brought or filed, they always end up with a lot of media attention, I think. That is just the nature of those types of open government issues, and a violation could also result in suspension or removal from office. So having gone over the basics of the Sunshine Law, are there any questions? I feel like I tried to cover virtually every... Yes, ma'am.
I have a question about virtual meetings, or because, our county is so long, we have some advisory councils that allow individuals to participate by teleconference. Does the entire public need to be invited to those as well? I mean, I think Bob can talk about it.
Yes.
Yeah, he's done. He can. You have great. He sent me the rules. The question is, what about these virtual meetings held in Monroe County? And the rule is very thorough in my experience.
Right. So we had the legislature pass a special act that allows advisory boards, allows the boards to do it as long as they're not taking final action, but the meeting is open to the public. So the individual advisory board can decide whether they want to just have an entirely virtual meeting or whether they'd have to have it at a location to allow public input. And I think, if I remember, it's been a while since I looked at the rules, you have to have a spot, because not everybody has a computer,
Right.
where the public can go and engage in the meeting as part of the process.
So I have a related question that has also to do with the emergency. During the storm, and immediately after the storm, we had all those Zoom meetings. There were like 100 and some people on those meetings. So my first question is, who got invited? And second, did we have to take minutes of those? Each of those? I mean, we had 3 a day.
That was not a meeting of the county commission.
Okay.
That was not a meeting of a duly constituted Sunshine Board. It was the
Okay.
emergency management director who was back here earlier,
Okay.
and staff and electeds giving information and exchanging information,
Okay.
but it was not a collective board meeting that met.
Phew.
But at the same time, if I go to a meeting that there's more than one of us and something may be decided or discussed that could be decided, that has to be noticed.
It has to be noticed, has to be open to the public.
Yeah, has to be
They-
open to the public.
Those weren't meetings that were going to discuss things that were going to come before a board for a vote.
Okay.
That was the key.
Yeah, I would tend to agree that when you get into a situation where you're dealing with emergencies and trying to do the best that you can, and everybody is involved in their different capacities, that you're more in a situation potentially where you're essentially talking to members of different entities within the county government. So the response to storms is so unique, I think, in Florida. And maybe there's a case out there, but I'm unaware of it, that finds fault
And
under
you've-
the Sunshine Law.
Use the Mexico Beach example you gave us later. We all have to evacuate here. We have mandatory
Right.
evacuations for the public, and we have the county closed for a substantial period of time afterwards till it's safe to come back in. I don't think we could hold a public county commission or city commission meeting when the public is still prevented by emergency ordinance from coming to the meeting, and we can't hold our meetings out of county. So it's just a circumstance that we're just going to have to deal with under the Emergency Management Act. And
Right. I think that those circumstances, public officials in that situation are faced with choices. You're dealing with an emergency where people are depending on you for their livelihood in a difficult, dangerous circumstance. So I think there's a recognition that you're going to do the best you can in that kind of circumstance. Just the fact that you're always thinking about the Sunshine Law, just from the questions I've gotten here, show that you're less likely to have difficulty than sometimes you'll have people who are blithely just going along without even thinking about it. So how could the school board, for example, think that it was an emergency to hire a lobbyist and give an hour and a half notice when they've got one of the most active newspapers in the state, in the Gainesville Sun, that's constantly monitoring them as to what they're doing? So expending anything that involves expenditure of tax dollars, it almost seems to me as though then that you're going to have that heightened scrutiny on the notice and opportunity for the public to see how their funds are being spent. And you weigh that against a government agency like my Mexico Beach example, or what you all have lived through, trying to help people as best you can through a difficult circumstance. There's really no comparison between, in my opinion, between those circumstances. I think there was another, oh, I'm sorry.
So there's a group of people, citizens acting in the interest of the community, and they're not appointed by the board, solicited by the board, no member of the board to which they will bring their conclusions is involved. It just needs to be clear that this group is not subject to sunshine, and that they have no affiliation with the board. They're doing it totally independently.
Well, so the question is, what about a group of citizens that have no affiliation with the government? They're not an advisory committee. They're just something like, I'm thinking, a good government association that meets on their own, maybe a homeowners association. They have an interest in what the government does, but they're not associated with the government. And typically, in those circumstances, the Sunshine Law would not apply to a private entity like that. But I've learned over the years that if anyone ever has a question about the application of the Sunshine Law, the best advice I can give is to go to the county attorney and check to be sure. Well, sometimes that can be the best way to determine that there's not some kind of contractual relationship that the public is not aware of. But your question affords a good opportunity to say once again that the Sunshine Law applies to government boards and does not typically apply to private boards unconnected with the government and not performing a service for them.
Right. But if that was a board that was doing things on behalf of the government,
Right.
such as the Sugarloaf Volunteer Fire Department Board of Directors, they were acting as the county fire department. The court has held they were subject to the Sunshine Law.
That's,
A group of people don't like the way something's being done, and you think you don't have the right information.
Is-
We're gonna get together and give them all the
Right.
right information.
see, that is exactly the type of discussion that comes up with these private groups and why I think going to the county attorney's office is so important. The fire department is an excellent example of a group of private citizens that are performing a service for the government. Even though they're not a part of the traditional government, firefighting is one of the most important things that the government does. So if that function is delegated or assisted by a private group, well, then all the other open government laws flow along with it. So that's why it can be difficult to know all the facts and circumstances. On the other hand, say a private school, for example, if it's not a charter school, but a private school established by a church, for example, not typically subject to the board of that school, private, not typically subject to the Sunshine Law. So, any more questions? Yes.
One more. Let's bring it into today's world. Speak about the Sunshine Law relationship to the decision. Should it be made to have a cabinet meeting in Israel?
The cabinet meeting in Israel affords a good opportunity to talk about the state communications media technology rule, which is analogous to what is in Monroe County, allowing rules developed 20 years ago allow members of a state board to meet entirely through communication media technology. So when the governor and cabinet were in Israel, there was a live screen video in the cabinet meeting room allowing people to see and hear all that was going on there.
So it was kosher then, no pun intended.
I'm not going to even repeat that one. Yes, there was no case that I'm aware of that for a state board would prohibit them from, I can't go on, from doing that. And it was, I went down to the cabinet meeting room. I don't know if a lot of you have probably been in Tallahassee and seen the cabinet meeting room, so I wanted to see, well, how is that going to work? Because we've never had a cabinet meeting with a huge screen on there, and it really was amazing to think how many thousands of miles away that was going on. It's sort of a courtyard or something at the American Embassy, yet all broadcast here in Tallahassee, where they could hear the comments being made in Tallahassee and vice versa. Incredible. So moving on, I'm not really sure about that question. I kind of thought you'd ask something else, I guess, but it was interesting. It's definitely technology related. So, we have a couple of questions I forgot.
You got 10 minutes for your...
Oh, for the entire presentation? Well, I better move over then into the public records law, although these examples are interesting. If you want to go back and look at them in your notes, some of you may have already figured out the correct answers to this one, and it would be B and C. The county commissioners, it's not illegal for them to go to the football game and to talk to each other. The fact that the reporter is there is irrelevant. So A is not the right answer. But if they're discussing county business, regardless of whether or not it's on the agenda, they would have violated the Sunshine Law if in that circumstance. So D there. Here are all these different public officials gathered around. I put this slide in here because the answer, once you wind through all of these, you see only one county commissioner from A, one from B, a tax collector, and I threw in various local officials. This meeting is not subject to the Sunshine Law. They're not on an advisory committee, but county officials or city officials always tell me when I put a slide up there like this, something that we all know is true. Members of the public won't like this, and a lot of people will feel this is wrong. And so I think you have, just because you can do something doesn't mean that you necessarily should. So in this circumstance, where it doesn't look like this was any kind of emergency meeting, like was alluded to earlier, all of these people, even though this issue was not urgent, people will ask about that. This one is too small for me to even read, so whatever it is, it looks highly suspect, something about a meeting in a restaurant. No meetings in restaurants. So moving to the public records law. Our public records law, unlike the Sunshine Law, passed with little fanfare. Some might say people had no idea what was happening, that our public records law would be as broad as it is. The definition of public record has evolved from the first two sentences that came from the 1967 definition. Once material meets this four-part test of being a public record, then it must be produced if someone asks for it, and even more importantly in today's world, it must be retained in accordance with a retention schedule. And in this regard, the most important feature to me for public officials, and I remember this all the time, when I will get a text about public business on my private cell phone, someone will text me, well, I have a question about the Sunshine Law, can you call me? Well, that's related to public business. That text message is a public record. The fact that it's on my cell phone, my personal account, is irrelevant. Under the case law, I have a duty to preserve, in accordance with a retention schedule, any public records, regardless of whether they're on my private Gmail account or my private cell phone. Because the public records law clearly applies to all these communications, I always recommend our office policy, and that is, and I did this just the other day, I get these public record messages off my private devices and I put them in the government account. That is our policy in the Attorney General's office, but we really do it to protect ourselves. So when I get this text on my private phone, my first reaction is, oh, what a complete pain in the neck. If it had come in on my government phone, it would be completely preserved because it's on my government phone or on my government email account. Now it's come to my private account. I'm responsible. So if I don't want to be responsible, I need to forward it or take a picture of it, get it into the government account, and that's what I did immediately. It looks kind of weird. It's like a picture of my phone, yet the message is on there in my government phone, and with an email, I do the same. I tell people, please do not email me about public business on my private accounts, and I CC my government account on that response so they know where it's going. A lot of these texts and emails I'll get from media lawyers, and they like anyone else, they want to contact me right away, and I'll think, what are you trying to do to me? I can't. Suppose something were to happen to my phone. That's another point. When these records cases are coming up where people are asking for public records on private devices, government employees and officials have to produce these unless there's a statutory exemption from disclosure. I am telling you that when judges hear responses like, we can't produce these because they got run over by a backhoe, in one example, the phone, or the phone got run over by a truck, they're not really believing that. So I think the best thing to do, discourage people from sending public record communications on your private devices. If they come in anyway, I'm a perfect example of that, send them into the government account so that if something happens to your phone, you're not going to have to worry about it. More information about public records cannot be provided at this time because I'm going over and you all have already been here for 4 hours. But we have the records is established in Chapter 119. It's a very clear obligation, which is why government agencies have records managers, and the attorney's offices are there to help in records production. If an individual elected official or employee gets a public records request, the best you can do is consult with the county attorney's office or the board attorney to figure out how to respond to it. These attorneys take many hours, more than this, of continuing education, and I think they do a phenomenal job in helping to parse through what needs to be done. This is some other information which you can read. Most of it is evident, that especially that all public records, even those on private devices, have to be kept in accordance with a retention schedule. And no surprise here, there are penalties in the event that the law is not complied with. And these are a couple review questions. Here we have some additional resources that I'll say if anybody would like to have these, you can go online. No one has ever done that, in my view. After 2 hours of this, you've had enough, you're done. So I'll conclude here, being available for questions. Thank you very much for the opportunity to come to this